Okay, good morning.
We're not on yet.
Okay. All right.
Takes a minute here. We are now on.
Okay, good morning. This is a regularly scheduled meeting of the State and Local Government Committee for work session on 3 bills that have been noticed previously. Before we get to those 3 items, I would just go around the table, so to speak, and start with Representative Mark Bryant to introduce themselves.
Hi, thank you, Senator. I'm Mark Bryant from Wyndham. I represent House District 24, part of the town of Wyndham. Pleasure to be here.
Thank you. Okay, Representative Walter Reisman.
Thank you, Mr. Chairman. My name is Walter Reisman. I represent District 69, which is Bridgeton, Harrison, and Denmark. Thank you.
Okay, Representative Sean Paulus.
Representative Sean Paulus, represent House District 52, which is all of the city of Bath.
Good morning. Representative Randall Greenwood.
Thank you. Representative Rayla Greenwood, House District 82, which is Litchfield, Monmouth, and Wales in both Androscoggin and Kennebec counties.
Great. Representative Kathy Downs.
Yes, good morning. I'm Representative Kathy Downs. I represent District 130. I live in Bucksport, and I represent Bucksport and Orrington.
Okay, great. Representative Lynn Copeland.
Hi, I'm Lynn Copeland. I represent House District 14, which is downtown in coastal Saco.
Thanks. I would note that Representative Frances Head is going to listen in when she can. She's has a personal family commitment. So the next representative is Representative Toole.
Good morning, Mr. Chairman. I'm Will Toole. I represent the towns of Cutler, East Machias, Eastport, Lubec, Machias, Machiasport, Roque Bluff, Whiting, and Trescott Township.
Great. And my co-chair, Representative Ann Matlack.
Good morning. My name is Ann Matlack. I represent House District 92, which includes the communities of Cushing, Thomaston, South Thomaston, St. George, Matinicus, Cree Haven, and the Muscle Ridge Islands.
Thank you, Representative Matlack. So the 3 items we have today.
Oh, and if I could.
Oh, I'm sorry.
Oh, done.
I apologize, Representative Dore. I'm sorry. I apologize with the screen.
No, that will cost you a cup of coffee when we get back to the State House, Senator. Good morning. I'm Representative Donna Dore. I represent District 85, which is a portion of Augusta.
That's great. And in fact, the State House is in your district, so I should be more mindful of that next time. Thank you, Representative.
And I'd like to introduce our committee analyst, Lynn Caswell, and our committee clerk, Cheryl McGowan.
Great. Good morning. So, Lynn, we have 3 items on the agenda for today for our work session. The first one is LD, I think 115, is that correct?
That is correct, yes.
Okay, so LD 115 is a bill and an act to restore the former state of Maine flag. In terms of the process for the work session, why don't you, if you have a Representative Matlack, I don't know if you have a set procedure that you'd like to follow in this matter, or should we just have a discussion about it?
I think I would like to have Lynn walk us through it. She has prepared for us some very informative, very in-depth, but yet concise reporting on what these 3 bills are. So if Lynn could give us a précis of what we are looking at for this bill, and then the committee can discuss.
Yeah, and before you get to that, let me just let people at home know that LD 115 is the first bill, and then the next one will be LD 2, and then the next one will be LD 113 in terms of the order of how we're going to consider these. Lynn, if you could take the floor.
Thank you, Mr. Chair. So the first bill is LD 115, which is an act to restore the former state of Maine flag. And if I may I share screen something that the committee received last session? So in the 129th, the committee, I'm not sharing the right thing, am I? Do you see a field or a flag?
I see a flag.
Okay, so
with a
in the
star tree.
129th, the committee considered an identical bill, and that flag that I just shared with you was a rendition that someone presented to the committee as what they thought the flag, the old original flag looked like. So I just thought I'd share that with you. So this, in the 129th, there was a bill introduced. It was LD 687, and it was identical. The committee at that time, because it was the bicentennial 2020, and it was pre-COVID, the committee, and this was early or end of 2019, the committee decided to instruct the Secretary of State's office to develop a flag specifically for the bicentennial. And the Secretary of State did do that. It was a similar flag to the one I showed, but not identical. So that was what happened in the 129th. This bill is very straightforward. The preliminary fiscal impact statement says that there would not be a fiscal impact. I didn't identify any issues in the wording of the bill or any legal issues with the a law that would change the flag. I believe that Shenna Bellows, the Secretary of State, when she testified, gave a very detailed history of the Maine flag and how it came to be the way it is now. So that is all I have to really share with you on this bill. Senator Baldacci, I believe you're on mute.
Representative Paulus, as the sponsor, did you want to make any statements at this point?
I don't have to, I mean, I did my testimony. I think it's pretty straightforward for my testimony. Kind of the reasons why I presented this bill and why I think it's, we should recommend it. But I'm happy to answer questions and,
okay,
you know, discussion.
Okay, and Representative Toole, you have a question?
Yes, in regards to the fiscal note, what was the methodology for coming up with that? I'm a little confused and perplexed in a way about how there is none if state facilities are going to have to, replace flags, municipalities may have to replace flags. I'm just curious as to the methodology of that. So could we potentially get some clarification on that?
Representative Toole, I can absolutely ask. If my memory is correct, which, as you know, it's not always, I believe that last session, when they said no fiscal impact, it was because the law doesn't require anyone to actually change their flag. I think the comment you're making, Representative Toole, is a practical one. But I think that was the basis for the analysis, because people aren't required to change the flag. But I can reach out to OFPR and ask if they could send something to the committee if that is the committee's pleasure.
Mr. Chairman.
Yes.
I would say because during the public hearing that did, I believe Representative Dorr asked a similar question. It was ours, and I checked into it, but I mean, Lynn can check into it again. But the answer we got back was that there was no fiscal note because they understood that the flags would be replaced as the normal process of when flags get replaced. So it wouldn't be, the flag would be replaced immediately. It would just be a regular process of when the institutions get new flags, and replace them on a gradual basis, not an instant basis.
Okay,
So I believe that was the understanding we got, why the fiscal note was the way it was.
okay. Thank you. Representative Tool, did you have any other questions of?
Thank you, Mr. Chairman. And that does, from what Lynn said, based on last session and what Representative Paulus is saying, that does ring a bell. It does ring a bell. So thank you for answering that. I certainly I certainly appreciate that. And thank you for closing the loop on that.
Did you have any other questions, Representative Tool?
Oh, no, I'm sorry. I forgot to lower my hand.
No, that's all right. Representative Greenwood?
Yeah, just to follow up on that, my concern with changing the flag is that, we do have, over 500 towns in Maine that almost every town has a state flag. And I think it would be an unburdensome cost just to the local municipalities. But I mean, I do really enjoy the blue flag we have. I think it's a wonderful illustration of our history. I don't have any objections to anybody wanting to look at the old original flag that is being proposed here, but I don't think it needs to be changed to the official state flag. Thank you.
Okay. Thank you. Representative Walter Reisman.
Thank you, Mr. Chairman. This is more of a procedural question, I guess. I know there's been testimony on this. Is all the testimony collected in one place where we can access it? I know, like, when I go to the bill itself, it shows the bill, but it doesn't show any testimony on that.
Isn't the testimony under committee materials?
Maybe it is.
Yes, I think.
I'm on a different.
I think Lynn's giving me the thumbs up on that.
I gotta go to the committee first, not the actual LD number. I gotta go. Okay.
Oh, okay.
That's so. I'll try that. Thank you.
Okay. Yeah, Representative Lynn Copeland.
Hi, I just wanted to say in support of this bill that the blue flag has two white men on it. And I don't think that represents all the people in the state of Maine. And I think that's important.
Okay, Representative Ann Matlack.
Thank you. My comment would be that the flag that we currently have looks like just about every other flag in this country. And I think that the cream color flag with the tree and the star is unique and it's special. And that's why I am supporting changing it over. And because there is no requirement to do so, it would be up to the communities to do so when and if they choose to do so. And there is no fiscal impact on them, and there's no fiscal impact on the state because it's not mandated that the flags be changed by a certain date. Thank you.
Okay. Are there questions or comments? Representative Copeland, do you still have your hand up? Okay. Do we need to include a specific date to allow for a changeover? I mean, is there any interest in that, or just leave it the way it is?
It's fine the way it is.
Okay. Representative Toole, oh, I'm sorry. Cheryl McGowan, did you have your hand up?
Yes, I just wanted to let Representative Reisman know that there are 13 testimonies under Bill 115 that he can peruse through.
Okay. Is there any members of the public that signed up to speak for or against, or neither for or against this bill? And Lynn is Caswell, the OPLA analyst, is saying no. Representative Toole, did you have other questions or comments?
No, I just want to state that I'll be voting against this bill. I think we're in the middle of a pandemic and the state has a lot of other concerns to be dealing with. And this is not high on the priority list of dealing with the pandemic and dealing with our fiscal issues, and I will be voting a ought not to pass.
Okay, duly noted. Any other questions or comments? Cheryl, do you still have your hand up, or do you want to
Oh.
lower your hand?
Sorry.
Okay. And there are no members of the public that wish to speak on this matter?
We don't, during workshops, we generally don't have members of the public. We will ask for the sponsor of the bill and perhaps some other experts on the topics. For example, the Secretary of State's office might have wanted to sound in, but apparently not. So it's just amongst ourselves to discuss how we want to move forward with the bill.
Okay, are we prepared to take a vote on this matter? Is that what the sense of the committee is? Okay, does somebody want to make a formal motion regarding this LD?
I will. I move that we approve LD 115 and create and go back to using the old flag and move forward from there.
Okay.
I'll second that.
Okay, it's been moved by Representative Matlack and seconded by Representative Lynn Copeland. Any further discussion before we go to a vote? Seeing none, I would ask the clerk to call the roll.
Let's see. Representative Copeland, Lynn Copeland.
Yes.
Representative Lynn Copeland, yes. Representative Kathy Downs.
No.
Representative Kathy Downs, no. Representative Walter Reisman.
If I could just ask a quick question. Could you
Sure.
repeat the motion on the floor, please?
The motion on the floor is to approve LD 115.
Okay, I think, isn't the correct wording, wouldn't that be, we vote as an ought to pass for this bill?
Yes, you are correct, sir.
So can we start over and make?
Okay.
I'm-
So Representative Matlack, we'll start over, just because I want to make sure we're abiding by every procedure for everyone. Representative Matlack, do you want to?
I move ought to pass on LD 115.
Okay. Representative Copeland?
Second.
Okay, it's been moved and seconded that the LD 115 ought to pass. Madam Clerk, could you call the roll?
Yes. Representative Lynn Copeland.
Am I supposed to say yes or ought to pass?
Yes.
Yes.
Representative Lynn Copeland, yes. Representative Kathy Downs.
No.
Representative Kathy Downs, no. Representative Walter Reisman.
Yes.
Representative Walter Reisman, yes. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Representative Randall Greenwood.
No.
Representative Randall Greenwood, no. Representative Sean Paulus.
Yes.
Representative Sean Paulus, yes. Representative Francis Head, absent. Representative Mark Bryant.
No.
Representative Mark Bryant, no. Representative William Toole.
No.
Representative William Toole, no. Senator Ned Claxton, absent. Senator Kimberly Rosen.
No.
Senator Kimberly Rosen, no. Senator Joseph Baldacci.
Yes.
Senator Joseph Baldacci, yes. 5 yes, 5 no, 3 absent.
Did I get this?
You're on mute,
Wait a
Representative.
minute, I'm missing somebody. Wait, one-
Cheryl,
sorry.
you forgot to ask Representative Matlack to vote.
Oh my goodness. I don't even have you down here, Representative Matlack.
No.
Representative Ann Matlack,
Yes.
yes. I really apologize. So now we have a 6 yes, 5 no, and 2 absent.
Okay. So, yes, Representative Tool.
Not knowing how it's ultimately going to run out, but assuming the numbers stay where they are, the minority report would be ought not to pass.
Okay. Representative Greenwood, did you want to say anything?
I was just going to add what Representative Tool just stated.
Okay. Okay, is there any other action we need to take on this matter? Okay, seeing no hands, we can move on to the next matter. Lynn, why don't you just give us a brief description, because we're for the public, and as to what the LD2 is and what we're going to be working on.
Yes, thank you, Mr. Chair. So LD2 is an act to require the inclusion of racial impact statements in the legislative process. I would just like to note that the committee did invite the governor's chief legal counsel, Jerry Reed here. He submitted letters on this bill and the next bill, 113. I also see the Secretary of State Bellows is here. I'm not sure if she's here for both or one. And the sponsor for LD2, Representative Rachel Talbot Ross, is also here. So I'm going to describe this bill backwards. I'm going to tell you about Section 2 first and Section 1 second. Section 2 sets out a pilot program for the Legislative Council to undertake. It includes a study. Either the council or its delegate would first conduct a study to find out the best method and to establish and implement a system using racial impact statements for legislation. And just so we're all have the same understanding, a racial impact statement is defined in this bill as an assessment of the potential impact that legislation could have on historically disadvantaged racial populations. So Section 2, again, Legislative Council will conduct a study. They will prepare a report by November 1st of this year. Based on that report, they will implement a pilot project starting December 1st, so on the second session. That pilot project will involve at least one, but no more than 4 committees using a process to develop or to consider racial impact statements during the legislative process. At the end of the second session, within 30 days, the committee chairs from those committees will report back on the pilot program. And then the council, by December 15th of 2022, would then determine whether to expand or eliminate the use of racial impact statements. So that's the second section of this bill. The first section of this bill, as drafted, which I believe the sponsor's intent is different. So let me tell you what it says, and then what I think the sponsor had shared was her intent. The way it's drafted, it reads, I think the kind of traditional reading would be that state agencies are required to provide information to the legislature so that the legislature can develop a racial impact statement. And I believe that there was some testimony about that obligation being placed on state agencies. And I will note that the definition of state agencies includes not just traditional departments and agencies, but it includes the boards and commissions, the quasi-independent agencies, authorities and institutions. So it's a broad definition. So that's Section 1. From what the sponsor, and the sponsor is here, so if I get this wrong, I know she will correct me. What the sponsor's follow-up to this about Section 1 was that the intent was that nonpartisan staff would create a racial impact statement I believe that it would be similar to what OFPR does. And OFPR does reach out to the agencies and the departments for information so that they can do their job. So that, I believe, reflects what the intent of the sponsor was for Section 1, which would be nonpartisan office is responsible to create racial impact statements. Agencies have a responsibility to provide information. In my analysis, I attached the law that currently exists for nonpartisan staff. And it sets out what nonpartisan staff, and that's OPLA, OFPR, Legislative Information Office, Law Library. I'm missing someone. That's what our jobs are. And if you look to Section 12, which is on page 3 of my bill analysis, and I know you might not have it in front of you like the old days, that's how it's drafted for OFPR to do its job. So that may be, if I have correctly reflected the sponsor's intent, and if the legislature, this committee wants to have nonpartisan staff responsible for racial impact statements, that subsection 12 may be a template, so to speak, an example of how to write that in a way that clearly places the responsibility on nonpartisan staff. I also want to point out that there currently is a section in statute that I believe is on page 2 of my bill analysis. There already are a few sections of statute that require departments to provide information to the legislature. And one of them is, they're all in Title III, and one of them talks about, it's 165 subsection 4, talks about how the state departments shall furnish to joint standing committees such documents, material, or information as may be requested by a committee. I mention that because I think it segues into the next point I'm going to make. So just to recap, Section 2 of the bill is a pilot program. Section 1 has to do with racial impact statements. There may be some amending you want to do if the committee wants it to do what the sponsor intended. But I would like to now address what was raised by the governor's office as a potential issue, and that was a separation of powers issue. In this situation, which is this bill, which is different from the next one, where we also have a separation of powers issue. This one, I am not sure that so separation of powers, there's not a law, and Jerry Reed may say there is, but I couldn't find a case on point that said the legislature can't ask the executive branch for information. In fact, there are at least 3 provisions in current law where the executive branch provides information to the legislature. So I think it's pretty well established in statute when it comes to documents, information, materials. So I laid that out for you all if you had on page 2 of my analysis so that you could see the examples that currently exist in statute that obligate the executive branch to provide information. And my final point is, at this point, as is often the case, there is not a fiscal impact statement that has been done. So that, I think, walks you through my analysis. I can answer questions on my analysis, or, well, I can answer questions on my analysis if you'd like.
Thank you. Are there any questions from the committee members?
I'd like to hear about the amendment that's being put forward, because that might clarify where we're heading with this bill in general.
So we've received an amendment. So, Lynn, that's been shared with the members?
So I have not seen that amendment yet, so I'm not able to comment on it.
Oh, okay. So I understand we have received an amendment Representative Ross, do you want to speak? Have you, if we could forward that to all the members right now, that'd be great.
I have done that.
You have done that?
I
Okay,
have.
okay. So it should be in your legislative mailboxes. We're going to be able to screen share that amendment. That would be helpful. But Representative Ross, why don't you speak about what you'd like to, how you'd like to see it amended?
Well, thank you very, very much. It is an absolute honor to be with you this morning to talk about this bill. And I want to just acknowledge my gratitude to the over 100 written testimonies that have been submitted in support of LD2 as well. The amendment that was set to the committee in section that reads racial impact statement information under subsection 201, number 2. I am suggesting that we write in the word available, insert the word available on the third line in front of data. And then in the fourth line, add necessary for the legislature. I think that the analyst has captured my intention well, but I do see the absolute need to make it as clear as possible that the request, like those that we've gotten examples on already, is for any existing currently available data. Certainly this bill is not asking state agencies to provide data that they don't have. Nor is this bill asking for departments or agencies to go out and get that information within a time period that would make it impossible to do. So this absolutely is a request similar to requests to departments for fiscal information, for them to take existing available data necessary for the legislature, to prepare for not racial impact statements. So this is only for available data. What this affords us is when there isn't available data, when no data exists, it affords us the opportunity to understand that, to catalog that. And then the legislature can understand that none of this data exists and perhaps that we need to take some additional steps to get the data. But this particular bill is limited to what is currently available that can be provided in a timely manner back to the legislature so that that can be used by a nonpartisan office to prepare, similar to a fiscal note, to prepare for the racial impact statements. So this friendly amendment makes that very, very, very clear. We're talking about available existing data.
Okay, great.
I just wanted to mention that Cheryl has posted the where the amendment is. She's highlighted it in red.
Yep, thank you. So Representative Greenwood, you have some questions.
Yeah, I just tried to open the email, but it wasn't sent in a PDF format. It was sent in a Microsoft Word doc, which is proprietary. So could they resend that in a PDF format, please?
Yep, yes. And Representative Cheryl, did you get that request? Okay, I'm assuming she did. And Representative Toole.
Yeah, so I guess I have a question first for the sponsor, and I guess that would be my first question would be, is it the intent of the bill is that nonpartisan staff do this work? Is that correct?
Thank you for the question, Representative. That was always the intent, and I do think the bill makes that clear. Absolutely always the intent for nonpartisan office to conduct this work, similar to a fiscal impact analysis and statement. Okay,
so given that, I would like to hear from Suzanne Gresser or somebody from OPLA as to weigh in on that, on the process for that, as we're developing a new impact statement. I would kind of like to hear from them and get their feelings, thoughts on how that would play out. before we kick this around too much further. If that is the intent, and I wasn't really clear originally in the language, but if that's the intent, then I think we need to hear from them.
Okay. Representative Ross, you want to respond?
Yeah, if I may just point out that the bill is the first part of this asks the Legislative Council. I mean, this is the point. The Legislative Council is determining the best method to establish and implement the system of racial impact statements. So what we have to understand is the bill is not prescribing what that looks like. We are asking the Legislative Council to conduct a study to determine what is the best way to establish and implement these statements. So it is precisely the reason why to give it to the Legislative Council to conduct the study, so that we can understand all of the places, all of the ways in which racial impact statements should be used, and what that method of analysis should contain. This bill is not prescribing how that gets done. The intention, however, is for a nonpartisan office to conduct impartial, objective analysis for the use of the legislative process. So I just want to remind you that what this bill is actually going to do.
Okay, that's a good point. Representative Ann Matlack.
Thank you, sir. I guess my point would be that this initial step is for us to determine what we don't know, where our gaps in knowledge are, where our statistics aren't. And so for Ms. Gesser and her office to have to determine on their own what it is that's being requested when we're still not sure what is available. I think at this point it's an opportunity to know what it is that we're at, what we might be asking for, whether that's available, and who should be providing it. And at this point, I don't think people know, so I don't necessarily know that we could get a good response from that office. But that was just my understanding, that this is a first step in determining what it is that we want to know and where it might be, rather than determining the cost of what we think we might want.
Okay, and Representative Toole, you have your hand up.
Yes, and I would thank you, Mr. Chairman, and I would respond to that by saying we're committing staff resources to doing this work. We need to know if they have the capacity to deliver on those resources, to deliver on it up front. We need to have some direction there. And I think what is the obligation, both financial, time-wise, workflow management, that sort of thing. We also need to know if there's already a process in place for adding additional impact statements onto legislation, and what was done when the financial impact statement was added. We ought to have the history of that for context and see how we might improve the process.
Okay.
So those are things that we could really benefit by having nonpartisan staff provide.
Okay. I'll get to you in just a second, Representative Greenwood. Lynn Caswell, our OPLA analyst.
Thank you, Mr. Chair. I want to just share I did have some research done, and this might be helpful. There are 8 states that do have racial impact statements: Iowa, Connecticut, Minnesota, Oregon, New Jersey, Colorado, Florida, and Maryland. They do it in different ways. Some have legislative staff. About 3 of the 8 have legislative staff who do it. Some of the other states work with, for example, Florida State University does it in Florida. In Maryland, the nonpartisan staff work with 2 universities. In Minnesota, because in several states, the racial impact statements are limited to certain types of bills, the most common one are criminal. So in a couple states, because it's focused on criminal bills or child welfare legislation, in Minnesota, it's the Minnesota Sentencing Guideline Commission, and in Oregon, it's the Oregon Criminal Justice Commission. So there are models out there where the work is done by outside entities or some combination of in-house staff and outside entities. And again, I would say the vast majority of those states, the impact statements are limited to certain types of legislation, most commonly criminal types of bills. So there are models out there.
Okay. And Representative Greenwood.
Thank you, Mr. Chair. Do we have a legal definition or a statutory definition of historically disadvantaged racial populations? That can be very broad.
Okay, I would throw that back to our analyst.
I did not research that. I do not know if it's identified in statute. If it is not, there would not be a reason why the legislature could not define it. So if you wanted more clarity on what historically disadvantaged, you could give it a definition.
Right. Any other questions or comments? The one thing, first of all, this is a very important bill. I'll just give you my own comments. This is a very important bill. I think we're all aware of the history of racism. Hopefully we are, and how it has affected the course of our, our history as a country, as a state, as people. And the idea that we need to make state government more responsive and more proactive and more forward-looking is a really important idea. So let's not lose sight of, the big trees in the forest. That is really an important idea. I think it's an idea that's time has come, and it really is to make sure that we are running a government that is for everybody, everyone in this state. So I think this is a really important bill to move forward. I appreciate the fact that the sponsor has really made several efforts to make sure it's as workable as possible. And I also appreciate the fact that there is a mechanism there for it to be reviewed by the Legislative Council. The only thing I would add in terms of is that in terms of requesting a racial impact statement, I think that if we limit it to a legislative committee, or commissioner, it's always going to be the dominant party that's going to be able to request one and not a minority party. So I probably would like to see an amendment that allows the House minority the House Minority Office and the Senate Minority Office, or either one, to be able to also request racial impact statements. Because, in terms of the whole point of this is to allow people, regardless of whether they're in the minority or the majority, to have this important information. Representative Matlack, you have your hand up.
Yes, sir. It appears that we've got quite a bit of information that others would be interested in knowing more about, and we're not going to be able to answer that today. So could we find out from others? We would like to know about the impact on nonpartisan staff to the work in the next year or so. Also, a definition from Representative Greenwood. I would be interested in knowing if there was other information that other members of the committee might want to know before we move forward with this, and if we could then schedule another work session so that we could get the information. And if you think about information, you could get it to Cheryl between now and perhaps next week when we talk about this again. But I think this really is an important bill. And I think we should give it all the work that it needs, and that we should find out what it is we don't know, find out what other people do know, and then get back together and see if we can find a way to come up with a good response to the questions.
Representative Matlack, that's excellent. Representative Copeland, you had your hand up.
Yes, thank you, Mr. Chair. I think that an important point was raised, and I really think that we should ask our universities and colleges, the social work groups, to weigh in on this. What can they do? What can they learn? And how can they help us? Because that's, they're the young people coming up, and they understand that we need to care for everyone in our society. And so that would be a good project for them. It would keep our costs down, because certainly we are accountable to the taxpayers of Maine. And I'm pretty sure that you're going to get some buy-in on that. And I also want to say how important this is. I mean, we've seen division in our country. It's time to unify. We all have to care about all of us. And there aren't invisible people. Everyone matters. And I think that this speaks to that. And just as we, care about money in terms of how we're going to vote, we have the impact statement on the costs and the fiscal statements. We also care about people. So I think it's important to understand the impact of those with less of a voice. Perhaps that's how I feel about being representative of my community, that everyone needs to get a voice. So I'm raising mine now, and I'm letting you know that this is important. And it's really, when you look at it, it's looking to figure out how to get it done. It's not saying we're doing this and it's going to cost us. We're asking, how can we make this better for people? How can everyone in Maine feel included, and that their representatives actually represent all of Maine, not just one or another? We need to come together, and this is one of the ways that we can. This is an opportunity. And I would encourage everyone to vote ought to pass, as I certainly will.
Thank you, Representative Copeland. Lynn Caswell, our analyst, and then Representative Ross. I just want to have Lynn weigh in, and then I'm going to recognize you.
I just wanted to mention that there are tools, ways to craft this that may get to some of your concerns. For example, if your concern is what is historically disadvantaged, or your concern is about the costs, you could consider clarifying more to the Legislative Council in that pilot program. You could put some of these to the Legislative Council and say, in addition to answering about cost, please identify, how would you define historically disadvantaged? You could put those, so you could clarify in the portion of the bill that deals with the racial impact pilot program what questions you want answered. You could also require the council or its delegates to report back to a committee. So there are mechanisms for that you could put into the bill, I guess is what I want to say. And there may be many others that I have not really thought about. Those are just the ones that came to mind while you were talking.
I would note, Representative Matlack had an excellent checklist of issues that I think that we should address when we meet again as a work session. I think that should serve as a template on a lot of those issues. I think we can, as a committee, we can probably define what historically disadvantaged groups are. There are plenty of court cases that or other legislative statutes that can pinpoint what are those classifications, if you will. So Representative Ross.
Oh, thank you, Mr. Chair. I just wanted to echo what Ms. Caswell just offered. And that is, the purpose of this bill is to not do a prescription on what should be contained in racial impact statements and or the process for it. This bill is absolutely directing the Legislative Council to undertake a pilot to determine the best method to establish this system. So I could have come to the committee, I could have written this bill much, much more prescriptive as to what it should look like and how we should implement it in the state of Maine. And I appreciate those other examples, but those other examples are for other states that have determined what they want to focus on. This bill is so that Maine can make the best decision about how our state needs to pursue racial impact statements. And so for us to, in all due respect, to amend this bill to prescribe what that looks like now, we don't have all the information we need to do that. That's why the purpose of this bill is to take the time to look at all of those models and other types of examples for Maine to determine what may be the best way forward. This bill, if it's passed, gives the authority to the Legislative Council to answer all of these questions so that we're not prescribing it before we have all the information that we know. And I just really want to make sure that the committee understands that if this bill passed, all we're doing is asking the Legislative Council to come up with the best method that we could use to institutionalize these statements, if that is what the Legislative Council determines. So I don't want to go to, I just caution you to go down a rabbit hole that prescribes all of that, because the bill is asking the Leg Council to undertake a pilot in order to do that work.
Okay.
So thank you very much.
Very good points. Representative Toole?
Yes, and I guess I would respond to that a little bit, but also I would say that Representative Copeland really made some great points about unity and the need for moving forward in a precise and methodical way. I mean, the Legislative Council could conduct a study without a bill. I'm not saying that we don't need one, but they could do that without one. We have a bill, and I think we have an obligation to fully work it through and gather as much information as we can before proceeding. And with that, I also think we need to hear from Mr. Reed, as I had some questions for him. And I also wanted to get his thoughts on this, as the governor, the administration is also a partner in this and needs to be a partner in this. So I think we need to hear from him before we go too much further.
Well, I think that the course prescribed by Representative Matlack is what I would prefer to follow. Mr. Reed is welcome to make comments today, but I think the idea is that we're going to do some of the items that Representative Matlack did and then reconvene on this most likely within the next few days. I don't see this delayed much longer than 7 days in order to accomplish some of those issues. But Mr. Reed, could you introduce yourself and let us know what the position is of the executive branch?
Yes, good morning, Senator Baldacci and Representative Matlack and members of the committee. I'm Jerry Reed. I'm Chief Counsel to Governor Mills, and happy to be here this morning to share some thoughts on LD2. I'm pleased to be able to say that most of the concerns that we had with the bill as drafted, I think are being addressed or can be addressed in light of Ms. Caswell's summary of legislative intent and Representative Talbot Ross's description of what she's hoping to accomplish in the bill. So we were concerned that the bill as drafted was essentially outsourcing the responsibility to perform the development of these racial impact statements to the individual executive branch agencies, which we think are in most cases ill-equipped to do that important work. And none of the concerns that we are raising with the bill as drafted should be interpreted in any way to suggest that we don't support the goal of the bill. We completely agree that understanding the racial impact of proposed legislation is critically important, and we want to ensure that this legislation is effective in fulfilling that goal. So we wanted to ensure that, as we hopefully described in the letter, the work is most appropriately done by legislative nonpartisan staff. And we have no concerns whatsoever about the legislation directing agencies to provide information that the agencies already have to assist in the development of those statements. But the work ought to be done and ought to be controlled by the legislature's nonpartisan staff. Otherwise, you're subjecting yourself to the vagaries of changes in the political views of the executive branch. You would be subject to an executive branch potentially that would be uncooperative in performing this work. None of that makes any sense. The legislature ought to ensure that it maintains control over the development of these statements, and that's what we wanted to make sure happens. What I would request is, if the committee, as it sounds like it's prepared to do, will be scheduling a second work session, if we could have a chance to work with the committee staff and Representative Talbot Ross to ensure that the intent as described in section 2, entitled Racial Impact Statement Information, is conveying what was intended as clearly as possible. We'd love to have a chance to do that, but I don't anticipate any trouble reaching agreement on language that would fulfill the intent.
Thank you, Mr. Reed. That's very helpful. Representative Toole?
Thank you, Mr. Chairman, and thank you, Mr. Reed. I think that is very helpful. Two things looking over the legislation under Section A or Part A, Section 201, or actually maybe it's, yeah, I believe it's A. No, I think it's Section 2, I'm sorry, where it suggests that data analysis and other information necessary to prepare a racial impact statement. Is it your intention that the departments are going to be providing data but not analysis? I mean, analysis is different than providing data. And I don't know if you have any thoughts on whether the word analysis needs to come out. And the other issue I had was on Part E under Section 2. You may have an opinion, maybe not. It says anything else the legislature council considers relevant. That's a pretty broad statement that could open up a Pandora's box. And I wonder if you had any thoughts on that particular question as well.
Who are you directing that to?
Well, Mr. Reed, I'm sorry.
Okay, I wasn't sure.
I'm sorry.
That's all right. I just want to make sure I have the right person who answers it. Mr. Reed?
Yeah, I think that's a really good question, Representative Toole, and that's where we were having concerns with the bill as drafted, is that it could be interpreted as requiring the agencies to conduct original analysis of proposed legislation, including legislation the agencies themselves were not proposing, and that was a concern to us. But as I said, hearing the summary of the intent, I don't have any concerns that we won't be able to revise that language to clarify that point. So I don't want to prejudge whether the word analysis needs to come out, but I would like an opportunity to work with the sponsor and the committee staff to further clarify that point. I think your question is right on point.
And a follow-up, if I may, with that, if analysis is included, could that potentially trigger a fiscal note on the department's part?
Yeah, and that's really the same concern that we had. So we want to make sure it's clarified to avoid the need to put a fiscal note on the bill. I don't, from what I heard of the summary of the sponsor's intent, I don't think it is the sponsor's intent to require agencies to perform original analysis. That's what would require a fiscal note. To me, providing information and analysis that and data that the agency already has in its possession is very different.
Thank you.
I think that Representative Matlack, do you want to do we need a motion or you just schedule, say we're going to?
No, we could just ask the chief counsel to discuss with the sponsor. The
Right, I would
concerns that
ask.
have been raised.
Yep.
And also the questions that we have. I don't believe we need although Mr. Toole will correct me if I am wrong.
Okay.
That we just need to schedule an additional work session, perhaps in a week or so, when we have additional work sessions already scheduled. I'm sorry,
Right.
Lynn is waving that I'm.
No, I understand. Well, Representative Bryant, though, you had your hand up. What, you had a question?
Motion,
We can barely hear you.
until into the future at the discretion of the chairs.
I can't. Oh, I'm sorry. Oh, okay. Thank you. You want to make a motion?
Motion to table.
Second.
Okay. And Lynn, you wanted to state, I'm sorry, Representative, but I can barely, you kind of cutting in and out.
I was just going to say it would be a motion to table, which Representative Bryant just made and Representative Toole just seconded. So you're headed in the right direction.
Okay. So Representative Copeland, you have your hand up.
I do. Thank you, Mr. Chair. I just don't want this to get lost. So we're not going to table it forever. So can we put a time limit on when we're going to get back to it?
Right. I think we need to table it for a date certain.
Yes.
And the date certain, I would suggest would be next Wednesday. Because I agree, I want this to be acted on soon.
We do have next Wednesday set aside for public hearings or work sessions. We don't have anything just yet, I don't think.
Okay. Well, can you make a motion, Representative Copeland, to have a table to a date certain next Wednesday?
I move that we table this to next Wednesday.
Second.
Yeah.
Mr. Chair, we already have a motion on the floor.
Yes.
Good point.
Okay, so I couldn't hear the motion entirely. So Representative Bryant, can you unmute yourself? Representative Bryant, you made a motion. Can you accept a friendly amendment to a date certain?
Absolutely. I'm not sure a table in motion has any of that available to it, but to me, the chair sets the dates anyway, so to me, it's mute. But
okay. Well, one way or the other, we have a motion to table. Let me just indicate if the motion passes, it's going to be set for next Wednesday. Okay, so that we can act on it. So there's a motion and a second to table. Cheryl, you want to call a roll?
I will do that. Representative Lynn Copeland.
You're on mute.
Representative Lynn Copeland.
Yes.
Representative Lynn Copeland, yes. Representative Kathy Downs.
Yes.
Representative Kathy Downs, yes. Representative Walter Reisman.
Yes.
Representative Walter Reisman, yes. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Senator Ned Claxton, absent. Senator Kimberly Rosen.
Yes.
Senator Kimberly Rosen, yes. Senator Joseph Baldacci.
Yes.
Senator Joseph Baldacci, yes. Representative Ann Matlack.
Yes.
Representative Ann Matlack, yes. Representative William Toole.
Yes.
Representative William Toole, yes. Representative Mark Bryant.
yes.
Representative Mark Bryant, yes. Representative Francis Head, absent. Representative Sean Paulus.
Yes.
Representative Sean Paulus, yes. Representative Randall Greenwood.
Yes.
Representative Randall Greenwood, yes. 11 yes, 0 no, 2 absent.
Okay, so the motion is passage. What I would direct our staff to do is to set this as the first matter on Wednesday of next week so that we can complete this matter. And in the interim, I would ask that our staff and the governor's office work with the sponsor and other members of the committee to answer the questions that were outlined by several members so we can have answers to those. If we could have those emailed to us at least a day in advance, that would be helpful. And then we can take a final vote on this on Wednesday next week. Representative Ross and Mr. Reed, do you have any other comments you want to make?
No, thank you, Senator.
Okay, Representative Ross, anything else you'd like to add? Okay, thank you very much. Representative Toole, you have a comment?
Yes, just as by way of reminder, we have public hearings scheduled for 10 a.m. on next Wednesday. And probably, given that we can't move the public hearings, we should probably think about doing this work session after the public hearings, or?
Well, we can discuss that. We don't have to do that discussion right now. We can work on that with the staff in terms of the scheduling.
I just wanted to make sure folks were aware that we did have public hearings, so.
Oh, yeah, we'll work with the schedule. I just wanted to be clear that this is going to be dealt with on Wednesday, and we're going to do a vote on Wednesday. Okay.
Thank you.
Cheryl, you have your hand up. Thank you.
Yes, I would just like to remind Representative Matlack and Representative Senator Baldacci to send me the names of the persons you would like invited to that work session so that they are here at your disposal.
Okay, thank you. Thank you. So now we are on to the next item. Lynn, do you want to give a brief introduction of this item and then we'll have a further discussion?
Yes, thank you, Mr. Chair. The next bill for us to discuss is LD 113, which the sponsor was Representative Toole. This is an act to strengthen the co-equal branches of Maine government by ensuring the legislature has access to necessary information. So this bill would amend a chapter of statute concerning interbranch communication and coordination. And it would prohibit the governor from limiting access to department commissioners and an executive branch personnel when the legislature is looking for information to do the work of the people. This bill was, an identical bill was introduced in the 129th. It was sponsored by Senator Miramont. And at that time, again, it was identical to this bill. At that time, the governor's office came and questioned the constitutionality of the bill, similar to the governor's office this term. And the governor's office proposed an amendment which the committee adopted and which became law in the 129th. And the last page of my bill analysis highlights the language that was added by the 129th legislature. So the 129th state and local government did not put in language that required the governor to allow access to individuals. What was done in the 129th is there was language added to the findings section of the bill. And for those of you who have forgotten, the findings section is questionable about its legal effect. The court sometimes finds the finding section has the effect of law and sometimes doesn't. But with full knowledge of that, state and local government last session added language that is highlighted that says the legislature provides for shared participation in the lawmaking process, shared responsibility, and that the legislature finds any blanket policy by the executive branch that limits access to executive branch employees is severely, let's see, is contrary to these fundamental understandings and intentions of the Constitution. And it states that the governor should provide reasonable, accessible information and expertise when the legislature requests. So that was what the 129th did in response to this bill. So that's just for informational purposes. What I would highlight and segue into, as I mentioned before, there is the constitutional provision of a separation of powers between the branches. Specifically, it says, no person or persons belonging to one of these departments shall exercise any of the powers properly belonging to the other. So the question is, the legal question is, are you, legislature, exercising a power that properly belongs to the governor? And the power you're exercising in this bill is requiring the attendance of an employee of the executive branch. So as I mentioned for the prior bill, there are several statutes that require the executive branch to provide information, paperwork, documents. That's a little different than requiring the presence of individuals. And as I said previously, I am not aware of a court decision on the issue of whether the legislature can compel attendance of executive branch employees. So I don't think that the court has weighed in on that. What I can tell you is the legislature does have subpoena power, and with respect to executive branch employees. This would be different. This bill is different. It's not requiring the legislature to use subpoena powers.
Right.
So
Can you, at some point, I don't know if you can during this work session or not, but email us a copy of that statute, because I was going to add, that was the first question, was whether the legislature, because I assumed it had subpoena power. I'm assuming there are certain conditions on the use of the subpoena.
yes.
So it'd be helpful, because it would be helpful to just to look at that, if you don't mind just sending us a copy during. So are there questions or comments that people want to, Representative Toole, did you wish to speak on this motion, on this LD? I apologize.
Yes, thank you. And first, I want to apologize to everybody for not being able to present the bill last week. I had another commitment, and the previous hearing ran a lot longer than I thought it would. And so I want to thank Senator Rosen for presenting the bill in my place. I believe it's important that we do this. I supported similar efforts in the 127th and 128th when they were brought forward, and I believe that the legislature needs to have a co-equal say. And I've believed that since I got here. I know we all believe it. It's just getting around to it is the trick. And I supported this bill in its current form last session, and believe that it's a necessary and essential thing, that even if we have one instance of a case where a commissioner or department head doesn't show up at the direction of the chief executive, that's one case too many. And it certainly was the case in the past. And we all know what happened this past summer, which I alluded to in my testimony with the Labor Committee. And I just think one case is too many, and we need to, if we're going to move forward in a productive way, I think we need to have something like this in statute. I do also want to thank the administration. I know full well I've had great working relationships with the Department of Corrections and other departments during my time here. And I don't mean this to say that every relationship has been a bad experience. It has not. And I want to thank Mr. Reed for reaching out to me about a week before the public hearing on this And I certainly understand and appreciate, although I disagree, where he's coming from. So with that, that's all I have to say. I'd be happy to answer questions of the committee members.
Okay, are there any questions of committee members? Okay, we have a couple of,
Lynn had a statement. Lynn had her hand up.
oh, I'm sorry. Yeah. Representative Lynn Copeland and then Lynn Caswell.
Thank you, Mr. Chair. Representative Toole, the issue of the subpoena has come up, and I'm wondering why this is necessary and a subpoena can't be used.
I think a subpoena could be a slippery slope if it's not used. It could be abused, and honestly, it's something that's been whispered at. It's something we don't have a lot of information on. So I would certainly like to hear more about that, because that certainly was not part of the discussion last year when this bill came forward. And I definitely would like to hear more about that and ways of using it. But at the same time, I think I view this as the step before a subpoena, that the legislature is putting the administration on notice that you're walking down a path you may not necessarily want to walk down. And I prefer to not have to use a subpoena on when it's absolutely, unless it's a last resort. I would see this as a step before that. So, but I'm absolutely interested in learning more about the subpoena issue.
Okay. Lynn Caswell?
So I just want to let you know, I can screen share the provision of law on the subpoena if and when the committee would like to see that, instead of waiting for another meeting. So I do have it ready to share when you would like it.
Why don't you do that now?
Yeah.
Okay.
I'm fine with that.
Let's make sure I get the right one. So are you seeing a piece of paper that says 7 other subpoenas, etc.?
Yes.
Yes.
Okay, so that is part of Title III, Section 165. So this subpoena power is in Section 7. The legislature has to grant a committee the the subpoena power, which compels witnesses, production of documents. And that, when the legislature grants this power, the committee then becomes an investigating committee, which has a separate section of law on Title III, Chapter 21. So it is a very formal process. The legislature has to say to a committee, you can subpoena, and that makes the committee an investigating committee. But that's the general section of law.
Okay, that's very helpful. Any other questions? I think that Jerry Reed, Mr. Reed, the chief counsel of the governor, wants to weigh in on this. Is that correct, Mr. Reed?
Yes, thank you, Senator Baldacci, Representative Matlack, and members of the committee. Again, I'm Jerry Reed, Chief Counsel to Governor Mills, and thank you for the opportunity to speak to these issues. Let me say at the outset, I did have the opportunity to speak to Representative Toole, and I just want to say how grateful I am for how gracious he was with me. As he said, that we ended that conversation agreeing to disagree on the issue, but we had a very good conversation about it, and I appreciated the opportunity to do it. Ultimately, we think, I guess I'd say 2 things. One is, these 2 things may seem to be at tension to some extent, but the first thing is this administration is completely committed to working constructively and cooperatively with the legislature on the matters the legislature has before it. That has been our practice, and that is our commitment, and nothing that I'm going to say this morning should be interpreted as calling that into question. Unfortunately, or regardless, what the bill tries to do here is just beyond the purview of the legislature's authority. The legislature cannot, consistent with constitutional separation of powers, interfere with the governor's control over executive branch officials. And so even if this bill were to be enacted, it would be unenforceable, because if the legislature were to enact a statute that purports to direct the attendance of a commissioner or agency head at a legislative function over the governor's objection, and the executive branch official did not show up for that meeting or hearing, there's no recourse available for the legislature to enforce a statute. So it's ultimately, even if it were enacted, it wouldn't be enforceable. So we think that, the issue that Representative Toole is concerned about is a legitimate one, that the legislature needs to have a constructive relationship with the executive branch in order to do its work effectively. We're committed to that. And we think the appropriate resolution of those concerns was the amendment that the committee adopted and the legislature enacted last session to make those findings in law, to impress upon everyone the need for this cooperative relationship to work well together. But that's where it has to stop. There's no additional recourse available for the legislature to commandeer executive branch officials over the governor's objection. That's her prerogative under the Constitution to have the final say about whether one of her commissioners shows up for a given hearing or not. And that's just the way our system is designed.
Okay, I think that Representative Ann Matlack wanted to speak. Ann? You're on mute. Oh,
Let go. No, it wouldn't let go. Yes, sir. I was wondering if I might get the chief counsel to give us his thoughts on the subpoena power, seeing that this has been brought up and it's something that others are interested in hearing about. I would like to have his perspective on whether or not that is actually a recourse, or whether that is also something that pertains to the separation of powers and would not be necessarily be enforceable.
Yeah, thank you, Representative Matlack. I think it's a really interesting question, and it's like a law school final exam question on constitutional separation of powers. To what extent legislative bodies can subpoena executive branch officials and then enforce those subpoenas, or ask the judicial branch to enforce those subpoenas. And you see that playing out at the federal level sometimes. And it's, in the end, it almost always is kind of a constitutional standoff. So I'm not here this morning to make any news by calling into question the constitutionality of the statute that's in place right now that allows the legislature to subpoena individuals, including potentially executive branch officials. But when push comes to shove, I do think that there are interesting constitutional questions implicated by that. And usually those are resolved short of wrestling the issue to the ground in court. There is some resolution reached between the two bodies that allows the legislature to get the information that it needs. And again, that's just the tension that's built into our constitutional framework. But so I guess that's how I'd leave it on the issue of constitutionality of legislative subpoena power over executive branch officials.
Okay.
Thank you.
We also have Tim Feely. Tim, you're from the Attorney General's office, correct?
Like Jerry, that was a former life. I'm deputy counsel in the governor's office.
Oh, okay. I apologize. Did you have it? Okay, so you're here. You don't have any statements other than what Mr. Reed has indicated. Right?
Nothing to add.
Okay.
Jerry, thank you.
I just want to make sure. Is there any members of the committee who wish to say anything? I just want to indicate that I think that the goals of Representative Toole's bill are excellent. I think that whether we're in a minority or majority in terms of party, that the executive branch has a duty to work with the legislative branch. I understand what Mr. Reed has said, but there is a subpoena authority in the statute, and I'm hoping the governor's office doesn't believe that that's unconstitutional, because the recourse to that would be going to court. State personnel are routinely subpoenaed to court actions. Generally, the subpoenas go through the Attorney General's office, but legislative subpoenas shouldn't be treated any differently than a court subpoena. But I'm not sure. I think the appropriate thing for this would be to table it for a period of time. I do think that that we need to review the existing statutes regarding both subpoena. And I understand we looked at the statute, but I'd also want to have some time maybe to talk to Representative Toole or others, because I think the goal of making sure the documents are produced and the rest of it is important. And it doesn't matter whether we have, this isn't about this governor or another governor. This is just about the fact that we want to make sure the legislature has the appropriate ability to provide oversight. But I would ask if we could have a motion to table so that we could try to answer some of these questions, or is anybody?
I move that we table.
Is there a second to that?
Time definite? For time definite, or?
I would suggest that we have at least a couple weeks.
I believe that's the purview of the chairs, so it would be just a motion to table, and the chairs could determine the next meeting to discuss this matter.
And we will discuss that with the leads as well. So motion to table, is there a second?
Second.
Oh, second, it's moved and seconded, okay. So I would ask Cheryl to call the roll.
Yes. Representative Lynn Copeland.
Yes.
Representative Lynn Copeland, yes. Representative Kathy Downs.
Yes.
Representative Kathy Downs, yes. Representative Walter Reisman.
Yes.
Representative Walter Reisman, yes. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Representative Senator Ned Claxton, absent. Senator Kimberly Rosen.
Yes.
Senator Kimberly Rosen, yes. Senator Joseph Baldacci.
Yes.
Senator Joseph Baldacci, yes. Representative William Toole.
Yes.
Representative William Toole, yes. I apologize. Representative Ann Matlack.
Yes.
Representative Ann Matlack, yes. Representative Mark Bryant.
Yes.
Representative Mark Bryant, yes. Representative Francis Head, absent. Representative Sean Paulus.
Yes.
Representative Sean Paulus, yes. Representative Randall Greenwood.
Yes.
Representative Randall Greenwood, yes. 11 yes, 2 absent.
Okay, so we will discuss at the meeting of chairs and leads about the schedule for that. And is there any other matters to be brought before this committee today? Representative Matlack, is there anything further we should be doing?
Lynn has something. Lynn Caswell has something.
Lynn?
Thank you, Mr. Chair and Madam Chair. So you are having the meet and greet at 1 today, but I was also hoping to have the committee consider the committee rules. So I'm just throwing that out. I don't know if you want to do that now or after the meet and greet.
That would be fine with me.
Do it now or after the meet and greet? Representative Matlack, what's your preference?
I'm happy to do it now. I think we're fairly in unanimity about this, and we might as well just move along with it.
Yeah.
If Lynn would like to quickly go over the changes, I know that in our chairs and leads meeting a couple of days ago, we did add another one with regard to eating while on camera, as in don't. But other than that, I think it's what we have discussed all along.
Right. Representative Toole?
Yes, I would concur that I think we should be able to have a discussion about that before lunch and as opposed to late this afternoon.
Okay, Lynn, why don't you just give us the brief highlights and then,
Oh, come on, don't I get to share my screen?
well, I wouldn't, I wouldn't expect anything.
Come on, I'm getting
There we
good
go.
at this.
Yeah.
So the bills, the changes that are being proposed is that you can eat food during work sessions and public hearings unless you're in the committee room and you're supposed to be wearing face covering. In that case, you cannot consume food because that would require you to remove your mask. The number 3, it basically says if you're on an electric platform and you're eating, to please stop your video. We also discussed allowing a chair at the chair's discretion. A sponsor of a bill who's a member of a committee may testify. The new H and C is a prohibition against signs, posters, placards, or props during both a public hearing and a work session. And the final one was that committee members and others participating in a meeting through an electronic platform would not have substantive discussions using the Zoom chat. So if those changes are acceptable to the committee and the committee votes to approve those changes, then I will sign a letter on behalf of the chairs because they're going to tell me I can. And the proposed committee rules will go to the presiding officers who have the discretion to approve or deny the proposed changes to the committee rules.
Thank you. Representative Reisman?
Thank you, Mr. Chairman. I believe I brought this up the last time, but I'm not sure what the answer was, so maybe you can refresh my memory. But I have a concern about when there are subcommittees within a committee and how that is handled within the rules so that, we have proper public notice and all that kind of stuff when it comes to subcommittee work.
I think we discussed that, but Lynn, do you want to just remind us what the rules say about subcommittees?
Yes, and I apologize, Representative Reisman. I was asked to discuss that when we talked about the rules. So it's very clear in the joint rules and under statute that if it is a true subcommittee of a committee, those are public meetings and they do need to be noticed and they need to be somehow the public needs to have access to them. It could be just through an audio link. In the COVID world, it's through a YouTube as well in some situations. But the rules are very clear that if it is truly a subcommittee and it's a subcommittee meeting, that the public has access, which includes all members of the legislature. If I'm hesitating because what's not clear to me is if presence in the room, and I'm talking pre-COVID, so in the pre-COVID world, if presence in the same room as a public meeting is taking place, that is not clearly established in the rules. The rules say that they have to be publicly accessible. So it could mean that you can't sit in the same room as the subcommittee, but you have to be able to hear it or through the audio. So I think that's clearly established. If it isn't being followed, which I think may be the situation that Representative Reisman, you may have faced, that I don't think there's nothing you could put in the rule that would address the issue of if that rule isn't being followed, then what happens?
Okay. Representative Toole?
Yes. Yes, thank you, Mr. Chairman. So as we're going through these, I just wondered if we spoke before we went online this morning briefly about the process for those absent doing votes. If we could have Lynn go over that on the record, I think that would be helpful. I also think there's been some concern that I think we need to be clear that when we're doing a roll call, and this is in the rules, that we actually have a reading of the roll and not a show of hands on the participants list. And I think if that's everybody's understanding, I think we need to reaffirm that. And we don't necessarily need to change the rules, but we need to make sure that's everybody's understanding.
Okay, well, first item is, Lynn, I think that if you want to just let the general public know what the policy is regarding people registering votes in terms of the rules, just for general information, that'd be great.
I will do that. I know it's written down in one of the COVID policies. I just need to find it and then I can share it so that you all have a copy in writing. So you don't have to rely on my interpretation or Cheryl's. Does that sound like a good plan on that?
That's fantastic. Yes.
So we could
Yeah.
revisit that maybe in the afternoon or another session. Okay. So the other issue, what was the other issue you had, Representative Toole? I'm sorry.
Yes, I know it's in the rules that we had agreed during chairs and leads that we would do a voice roll call vote. Cheryl would go around the horseshoe and call our names and we would respond. And I've just wanted to make sure that is everybody's understanding that going forward, that's what we're doing, that there won't be any show of hands on the participant list or anything like that, that we're going to have a roll.
Right. We have to have both your video and your audio.
Okay.
I completely agree.
Thank you.
Yep. Any other questions, Representative Reisman?
Hello, thank you, Mr. Chairman. I just want to make sure that my position on some of the roles within the committee are clear. I understand there is a situation where the chairman and the lead folks in the committee may have a meeting and discuss certain procedures or points of view that may be coming up. And I find that a little unfair in terms of me being an independent and making sure that I'm included in that conversation. So
okay.
Based on that,
you get access via the audio, and the meetings that we have are not about substance. They are about upcoming meetings and so forth. But we don't talk about the content of bills or anything, just the names of bills, the numbers of bills, and what's coming up, what order they might want to be, whether we want to move bills forward and put them on the calendar and so forth. That's what it is. That meeting is noticed and audio is available.
Representative Reisman, I would just say that you're more than welcome, as Representative Matlack indicated, to listen and the whole, because we do have it publicly available. But if you have specific questions, I'm happy to deal with any concerns you have following those meetings. I'm happy to, because obviously I want the committee to run as smoothly as possible for all of us. And so if there are specific issues that come up, please feel free to tell me ahead of time that you want something addressed. Okay? I'm trying to make this as open to everybody as possible. Is there a motion to approve the rules as presented by the analyst?
Senator Baldacci, I'm sorry.
Yes, Representative Dorr.
Thank you. I just have a couple of questions and I just want to make sure that I'm perfectly clear. I go once a week for an infusion. I try to get it done so I can, still attend all the meetings, but that's not always going to be possible. So I want to make sure that I still have the ability vote on any issues up until noon the next day. Is that correct?
That is correct.
Okay.
And Lynn is nodding in agreement.
All right. Thank
That
you.
is absolutely correct.
All right.
I
Thanks.
believe that was what Mr. Toole, Representative Toole was asking earlier.
Right.
I wasn't sure whether we missed that one or not, or whether that was what Lynn was going to
That's what Lynn was
get
gonna
information
give.
for it to us.
Well, she was going to give us the whole rundown, but Representative Dorr, you are absolutely correct. The essential bottom line is that you have until noon of the next day to register a vote.
All right. Thank you.
Thank you. Now, Representative Greenwood.
Thank you, Mr. Chair. Just so you know, out of principle, I'll be voting against the rules because I think we should be in person. That being said, my next question is, those proposed rules that we'll be voting on, they include provisions for Zoom. Is it assumed that in the second year of this session, we will be Zoom? Is that why it was incorporated into the general rules, or should they be voted on differently and separately?
Okay.
I can answer that a little bit.
Representative,
The presumption is that the rules are generally what we had experienced in years past, in sessions past, and that we were including information about Zoom at present because that is the nature of how we meet right now. For example, eating food and drinking and having drinks in the committee rooms is something that going forward we would be able to do. But at present, the Zoom rules are in effect until we are no longer in Zoom. We wanted to be able to cover bases for now and for later so that everybody doesn't come back in a year's time and have to redo all of these rules. So this is just making sure we talk about everything about the nature of the way we work now and how that will affect the nature going forward. For example, the placards, et cetera. That would be in place now and later, because it's always been that you're not allowed to have whiteboards or anything else in the committee rooms. But as far as Zoom is concerned, when we don't Zoom, we don't Zoom.
okay.
And no, I have no information about next session or when we'll go back to regular in-session meetings, but this is just to make sure that we can meet now and then also meet later.
Correct. There are very few assumptions made beyond that. Cheryl?
Yes, here are the rules that we are given as a clerk for voting. Members may vote during an electronic meeting as long as the chair is able to see both and hear the member casting the vote. Members may not vote if they are participating by call-in, audio call only, or have their camera turned off. Members who were absent at the time of the committee vote have until noon on the second business day after to register their vote with the members of the presiding officer.
Thank you. So the second business day means basically 48 hours or a day and a half, depending on when the.
And it's with the members of the presiding officers.
Yeah. Okay, thank you.
Yep.
Is there a motion to approve the rules as presented by our analyst? Representative Matlack, do you want to make a
I
motion?
move to approve the rules as amended by this committee.
Okay,
Second.
it's been moved and seconded. Any further discussion, questions, comments? Representative Toole.
Yes, did we want to take Representative Greenwood's suggestion under consideration and separate the COVID and the regular, or?
Well, we can always, are we only allowed this one opportunity to amend these rules?
Yes.
We are.
Yeah, I first of all, I didn't hear him request that we separate. He asked about when, whether or not we knew Zoom would still be in effect next session, as in next January. We hadn't heard a recommendation, and no, we'd have no idea when this will stop.
Okay.
Right. I think that we're dealing with today at this point. I guess if circumstances change and we're back in the legislature, we'll have to, can re-examine things there. But So we have a motion and a second. Cheryl, will you call the roll?
I will. Representative Lynn Copeland.
Yes.
Representative Lynn Copeland, yes. Representative Kathy Downs.
Yes.
Representative Kathy Downs, yes. Representative Walter Reisman.
No.
Representative Walter Reisman, no. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Senator Ned Claxton, absent. Senator Kimberly Rosen.
Yes.
Senator Kimberly Rosen, yes. Senator Joseph Baldacci.
Yes.
Senator Joseph Baldacci, yes. Representative Ann Matlack.
Yes.
Representative Ann Matlack, yes. Representative William Toole.
Yes.
Representative William Toole, yes. Representative Mark Bryant.
Yes.
Representative Mark Bryant, yes. Representative Francis Head, absent. Representative Sean Paulus.
Yes.
Representative Sean Paulus, yes. Representative Randall Greenwood.
No.
Representative Randall Greenwood, no. 9 yes, 2 no, 2 absent.
Okay. So it appears the matter has passage, but obviously 2 members are allowed to register their votes on the second business day by noon. Anything further to come before the committee? Seeing none, we can recess the committee until 1 o'clock. Thank you.
Yeah, remember that the YouTube video is not turned off. So if you would please log out of, or just turn off your video and your sound, that would be wonderful.
Right. Thank you.
Good afternoon.
Good afternoon, Madam Chair.
Good afternoon.
Representative Matlack, would you like me to let the first two persons in, or do you want to wait until you introduce everybody?
Let's wait another minute or two. I have like, we're a minute or two ahead. So yeah, let's see who else will be rejoining us again.
Okay.
Thank you.
So we have 11 on our list, but only 2 are in the attendees spot right now. Three, just found one.
Just for my own information, I noticed that somebody has been posting to the chats. I'm not sure who that person is, but I think it's on topics that are not appropriate for chat. Maybe I'm wrong, but first of all, I'm not sure who that person is.
I tried to disenable the chat, but I was not able to do that for some reason.
Okay.
I did disable it, but they still were chatting. So I don't know if it was afterwards or before.
Thank you.
If I may, the gentleman who was chatting did sign up to for the meet and greet this afternoon, but I see that yeah. So maybe he's planning on coming back.
Yeah.
Okay. Thank you. All right. So check my phone again.
So Lynn,
Almost that time.
Good afternoon. Lynn, we have a number of meet and greets. Do you want to just give the public just a listing of who we're going to be meeting with today? And
Yes, thank you, Mr. Chair. So the first two people who will be speaking to the committee are from Volunteer Maine. There's Celeste Branham, who's the commission chair, and Mary Alice Crofton, who is an executive director. And then Stephen Gordon is the president of the Maine County Commissioners, and he may have with him James Cohen, who is the lobbyist for Maine County Commissioners. And then on the list, I don't see right yet, is Roberta Manter from Maine Roadways, Bradley Sawyer, who I see is here from Rural Water Association, Ken Capron, who was here earlier, I don't see him right this moment, Kimberly Cook from the Mayor's Coalition, Nancy Smith from Grow Smart Maine, and Allison Susi from Maine Tourism Association. And Allison, if I've pronounced your name wrong, I'm very sorry. So first up are Volunteer Maine, Celeste Branham, and Mary Alice Crofton.
great. So now that we're back here, I just ask each of the representatives who are present just to introduce themselves again for members of the public, starting with Representative Greenwood.
Thank you, Mr. Chair. My name is Randall Greenwood, State Representative for House District 82, which is Litchfield, Monmouth, and Wales in both Androscoggin and Kennebec counties.
Great. Representative Sean Paulus, if he's on.
Yep, I'm right here. Sorry. Representative Sean Paulus, House District 52, represent all the city of Bath. Thank you.
Thank you. Representative Donna Dorr.
Good afternoon. I'm Representative Donna Dorr. I represent District 85, which is part of Augusta. We do have a little port though.
Thank you. Representative Kathy Downs.
Yes, good afternoon. I'm Kathy Downs. I represent District 130, which is Bucksport and Arlington.
Great. Representative Walter Reisman.
Thank you, Mr. Chairman. My name is Representative Walter Reisman. I represent District 69, which is Bridgeton, Harrison, and Denmark, and includes Cumberland and Oxford counties.
Okay. Representative Mark Bryant, if he's on. If he's not, Representative William Toole.
He's
Okay.
not here either.
And Representative Francis Head, I think, had a personal or family commitment. Representative Lynn Copeland.
Hi, I'm Lynn Copeland, and I represent District 14 is what I represent. That is downtown Saco and also the coastal region of Saco.
Great, thank you. Senator Rosen.
Thank you. Good afternoon. I'm Kimberly Rosen, Senate District 8. My district goes from Castine through the city of Brewer all the way up to Lincoln, and I live in Bucksport.
Thank you. And my co-chair, Representative Ann Matlack.
Good afternoon. My name is Ann Matlack. I represent House District 92, which includes the communities of Cushing, Thomaston, South Thomaston, St. George, Matinicus, Creehaven, and the Muscle Ridge Islands.
Thank you, Representative. I just want to emphasize, Representative, that the last name is Matlack. Some people had gotten it mixed up with Matlock, but I just want to emphasize.
Some people watch too much television.
They watch too much television, exactly. So my name is Joe Baldacci. I'm the state senator from District 9, which is the city of Bangor and the town of Herman. And welcome this afternoon. So I think Celeste Branham, you're up. Welcome to state and local government.
Thank you. Senator Baldacci, Representative Matt Lack, and committee members, good afternoon. Thank you for extending this opportunity to introduce you anew or for the first time to the Maine Commission for Community Service, our statutory name, but we are now known as Volunteer Maine. As Senator Baldacci indicated, my name is Celeste Branham from Brunswick, Maine, and I'm in my second term as chair of the commission. Also joining me in this Zoom meeting is our intrepid, knowledgeable, and very effective executive director, Mary Alice Crofton, who has served in that capacity for 25 years, and she has agreed to assist me in answering any questions you may have at the conclusion of this presentation. Your invitation to come before you specified that you are interested in hearing about our purpose, our work, and the accomplishments of Volunteer Maine. First, I should tell you that the Joint Standing Committee on State and Local Government are the Commission's oversight committee, as described in our enabling legislation. And the Maine State Department of Education is our fiscal agent. Those of you who are new to the legislature have recently received a congratulatory letter and infographic from me about the commission. So I promise I will only reiterate some of the highlights from that material. Volunteer Maine, the State Service Commission, was established by Governor McKernan through executive order in 1994 and by state statute the following year in 1995. Our board may have up to 25 members appointed by the governor for 3-year terms, representing different areas of the volunteer sector, such as local labor, out of school and at-risk youth, business, delivery of environmental services to communities and persons, and educators, including representatives from higher education, which is the category in which I serve. Importantly, our mission is to foster community service and volunteerism that meets the human and environmental needs of the state of Maine. We do this by focusing on building capacity and sustainability in Maine's volunteer sector, developing managers of volunteers, fostering adoption of high-quality volunteer management practices, raising awareness of volunteer sector issues, and promoting service as a strategy to help solve local problems. Notably, we create a significant economic benefit to public and nonprofit organizations beyond what is available to them through their own financial resources. Volunteerism contributes $934 million to the Maine economy in terms of pro bono labor. We are also leveraging over $1 million in local in-kind and cash resources to support volunteer community services. Our commission is Maine state government's partner to AmeriCorps, formerly known as the Corporation for National and Community Service. In the last year, 2019-2020, we oversaw $1.9 million in national service grants to local organizations. The AmeriCorps programs alone have members working on a wide range of grant-funded programs, and we're engaged in education, recovery coaching, health and economic opportunity programming as they continued to serve during the pandemic. They have contributed approximately 105,000 hours of volunteer service during that time. But since 1994, over 6,300 Maine residents have served more than 8.9 million hours and have qualified for over $21 million in AmeriCorps education awards. Now, based upon an extensive review of studies and strategic plans developed by state agencies, offices, and boards, as well as statewide associations, such as the Maine State Community Action Coalition, the Commission approved a slate of priority areas to guide our grant funding over the period of 2021 through 2026. These priority areas are public health, including mental health and substance use, workforce development, including green jobs and climate crisis action, housing with an emphasis on affordability and safety, and environmental stewardship and sustainability, which also encompasses emergency preparedness and aspects of transportation. By statute, Volunteer Maine has a role in the state's emergency response. To that end, we established within 72 hours in March 2020, maineready.org, a website that enables community and regional organizations that are responding to emergencies such as the pandemic to call for volunteers, to communicate regarding shifts and assignments, and to manage deployment. Just this month, for example, 3,000 Medical Reserve Corps volunteers who are managed by the CDC were integrated into maineready.org to assist in setting up field operations for public vaccination activities related to COVID-19. The Commission is currently conducting research related to the impact of the pandemic on community volunteer services, the results of which will be ready for distribution in June. In the meantime, however, we have accessed federal funds to support one FTE dedicated to training and technical assistance for community volunteer leaders who are trying during this time to adapt operations so that they might maintain their services. While an expansion of AmeriCorps is occurring federally to assist with pandemic response and recovery, research conducted in Maine indicates that rural communities are not able to plug in to AmeriCorps because of the burdens associated with administering federal funds. This is the reason the Commission devoted time within the last year to complete the design for the Main Service Fellows Program. This program is intended to engage recent college graduates in full-time service to rural Maine communities to address local unmet needs through volunteer-driven solutions. This would be a timely and needed venture to communities to help them in rebounding from the local impacts of the pandemic. One of your colleagues, Representative Morgan Riley from Westbrook, is submitting legislation to support the Commission's Main Service Fellows Program. We know that intense community service experiences and attachment to communities are a way to attract and retain talented young adults. During the 28 years the Commission has administered AmeriCorps grants, our data has shown that well over 1/3 of young adults who move to Maine for service tend to stay in Maine when their service is completed. Our 2019-2020 Annual Commission Report is being prepared at present, and you will receive a copy upon its publication within the next few weeks. What you will read therein is that we, Volunteer Maine, contribute to the civic health of our communities by encouraging citizen participation. This has a direct bearing on whether a community prospers or struggles in addressing public problems. Research clearly suggests that communities with strong civic health in which citizens are highly participatory, one, are more resilient when hardship befalls them, two, have more effective governance, and three, are considered places with a higher quality of life. At Volunteer Maine, we are deeply proud of our work to enable communities to thrive through volunteerism and civic engagement. And I thank you for your kind attention.
Thank you very much, Ms. Branham. Are there any questions of the committee? Ms. Branham, Representative Riley's bill, what specifically does that call for?
Yes, it calls for the establishment of the program that I've described, namely allowing for recent college graduates to provide full-time service in communities that are rural in nature.
And how many college students would this be open to? Do we have a number?
Yes. Mary Alice, you're muted.
Sorry.
Hi, Mary Alice.
Hello, sir. It's very nice to see you again.
Nice. Thank you. Nice to see you as well.
So it's not out of the revisor's office. I haven't seen the final. We've been talking about a core group for public support, and then over time, if it proves to be as good as we think it's going to be, then being able to accept private support to grow it.
Right.
But as I said, the bill is not, it's not an LD yet.
Okay.
Senator Baldacci, we have, in fact, this afternoon, a meeting with Representative Riley to sort of iron out these details.
Oh, great. Okay. Thank you.
Mm-hmm.
Mary Alice, did you want to make some comments? Or?
Sorry, I forgot to take my hand down. I hit that instead of
That's all right.
unmute.
Did you, oh, I'm sorry. Ms. Branham, did Mary Alice want to make some comments or?
I don't believe she did, although, no, she's shaking her head in the negative.
I just want to make sure.
Yes.
It's a little bit clunky with the Zoom sometimes. I just want to make sure everybody gets recognized.
Thank you.
Well, thank you, Ms. Branham, and thank you, Ms. Crofton. If there are no questions, I think we can go on to the next group. But thank you very much for your time.
Thank you to the committee as well.
Thank you.
Thank you.
Okay, Lynn, who is our next speaker?
So
The next speaker is Steve Gordon.
Okay,
And
Steve?
the two ladies and one lady and one gentleman that were with him have not signed on yet.
Okay, does Steve want to go ahead, or does he want to? Is Steve on?
He is. I'm
There
not
we
sure
are.
where he
And
is.
is Attorney Cohen also on?
No, she's
No, he
not
doesn't.
in my attendee list.
Oh, okay. Steve, good afternoon. You're on mute. You need to unmute yourself.
There we go.
There we go. Steve,
And
good
yes, sir.
afternoon. Can you introduce yourself and
And you, sure, and I'll
well,
go right into what I've.
yeah, that would be great.
Although I find that I've mixed up a couple of things, but we'll make it work.
Okay.
First, Senator Baldacci, members of the local and state and local government committee, I appreciate the time to listen to what we have to say and to orientate you a little bit to what county governments are. I'm Steve Gordon, presently chair of Cumberland County Commission, the Cumberland County Commission, and president of the Maine County Commissioners Association. We represent 15 of the 16 counties, and as you can imagine, because of the makeup of the state of Maine, there's a lot of independent people, so we have one county that doesn't participate. Hopefully, when I'm finished from the 30,000 foot level, both you and the committee and I will have a better understanding of what counties are. First and foremost, in Maine, the 16 counties are unique. In addition, they are our state's oldest form of public government, predating statehood and the Declaration of Independence. They're set in the hierarchy of governments between state government level and the 488 incorporated municipalities. They're funded by property tax, our most regressive form of taxation. And more importantly, this regional form of government offers your committee opportunities for regionalization of duplicate public services. Major tensions that we have in our system and how we serve is that the areas are two or three. One is home rule, which is a topic that always comes up with us, and we talk about it. And I would suggest to this committee, if you wish to speed up local consolidation of public services and lowering of the cost per capita, allow counties to have home rule. By adhering to these laws that we don't enjoy those opportunities, the present laws, and as a result, we have to take everything that we need forth to the legislature as a bill to have it authorized. And as you can imagine, the turnaround time sometimes is a year, other times it's 2 years. And by that time, the opportunity to provide the services that were being requested has disappeared. The revenue in property tax is approximately for all the services that we provide, and I can go into that a little bit later, but I'll make mention of it up front here. If you have a roughly in Cumberland County, for example, if you have a $400,000 home, which I realize is high, the taxes are $260 for the property tax to support all the county services that they receive. So we think that's a pretty good ratio and deal for the public in that it's fair and equitable, and when they need the services that we provide, they are available. And let me go into them. First is the Sheriff's Department, which of course includes the jails. And that department with the jails is about half or a little over half of our budget. So we're constantly looking at the Criminal Justice Committee because they are ones that control what goes on in the jail and how that functions. Probate. They provide judicial services by an elected judge, and the House and houses probate documents through its elected registrar. And there's a multiple of services that they provide: adoption, guardianship for minors, estates, trusts, conservatorships, name changes, and support enforcement. The Registry of Deeds works with the public, attorneys and surveyors and engineers to provide land transactional informations. And they store these instruments of such as deeds and attested copies as needed. Emergency management. This is an important one. It incorporates all the available emergency resources on a county-wide basis to mitigate, prepare, and respond and recover from disasters. They also provide an operational center for the coordination of all inter and intra-county-wide emergency operations. And as you can imagine, when things are really in need of a disaster response, to have an ability to coordinate communities, to provide that, it's extremely important. And they stay out of sight, but they do their job extremely well. District attorneys, they're elected officials, of course, and they provide the prosecutorial services of the judicial court. They and their assistants are state employees. However, the counties provide their facilities, the personnel, clerks, and advocates, and the provisions to run the office and the facilities. Courts, most counties provide space for superior and district courts and their utility and functional services, and then auxiliary services. In addition, we, for example, well, a lot of counties provide additional services which the communities pay for in on a pay-for-use basis. For example, tax assessing, 911 or PSAP communications and dispatching functions for local EMS and fire and protection, part-time services such as fire chief functions for smaller departments, and we even have one that does airports. So it's a myriad of issues that slowly are beginning to gravitate to the counties because the communities find that it is to their advantage in the services by combining services and the service level and the cost of it. Governmental services for unorganized territories. It varies across the state. We have one county that has over 100 of these unorganized territories, or UTs, and we have others that have none. So as you can imagine, that kind of shows us the variation that we have across the state with counties. And I implore you that if you do write legislation for counties, that you take that into account and provide flexibility, because in some areas they can afford or they can apply the requirements, and in others they can't. They would have to form some sort of either a collaboration with another county or hire out the service. As an aside, you'll probably see more. And we're talking about the UTs. As an aside, you'll probably see smaller municipalities, those less than 250 population, making applications to your committee to deorganize as more of the required citizen services become mandated and impact property tax rates. Now, as the sub character to that is, and I'm sure you're aware, this transfers additional expenses onto the rest of the county property taxes. So there's always a good and a bad to change, and it's just to make you aware of such transitions. You may interpret from my previous descriptions here that county government and their citizen services are evolving slowly, and that evolution is driven generally by a sudden change in a municipal cost structure, which in turn causes the exploration of alternative ways to provide services. The rate of that evolution is controlled by this committee. as the county government structure and its ability to serve requires a change in state law. A county is governed by commissioners, and according to the state constitution or the state law statutes, county commissioners have final authority over the operations of all county offices by elected or appointed officials, unquote. The commission is made up of 3, no more than 7, and some commissioners individually represent over 50,000 citizens. So that's more than your senators or others. And so they do have a number of things that they watch and take care of. Your 16 counties, as I've mentioned, are different. Their demographics, their culture, and it's not a bad thing. It's just, again, I ask you to recognize it so that when you are giving consideration to proposed legislation, that the appropriate flexibility can be built into it. Where are we here? The last topic that I'd like to talk about is our revenue. Well, actually, there's 2. And our revenue is where our worst tensions are, because we compete, or it's looked as though we compete with the municipalities for the legislation, for the taxes. In in the aggregation, our total gross annual budgets, this is for all the counties, is about $235 million a year, and we employ some 2,000 employees. The worst revenue tension is the state inhibits our revenue acquisition with LD1, but more draconically, its application of an absolute jail tax cap by one of the state governments, while others continue to add rules. And the absolute jail tax cap is a real contention for us. It indicates that we can only raise the level of the costs of the jail by an absolute amount, and yet we have requirements that are being placed upon us yearly that causes that to exceed. And so we are constantly coming back to the state asking for additional dollars to help subsidize that. The municipalities, with municipalities, the tension, as I've said, is between us, because they collect our taxes, which is an efficient way of collecting taxes. Otherwise, we'd be all sending out budgets. And we respect them, because with their educational funding of approximately 80% in their requirements plus their own governmental needs, they get precious little credit for what they do in holding the line on their budget. I will, at this point, I guess I will say thank you. I apologize a little bit here because I had something taken away from me here. But,
no problem.
But you are an important committee for us. There have been times when we've been before you and you've respectfully really taken a look at the issues. One was when they wanted to make all the commissioners get elected all at once, and that would have put a lot of problems in the counties, because if you don't have some historical perspective on board members, that could be a problem. That really would be a problem. With that, I say thank you for your attention, and I'll take any questions you would like at this time.
Sure. Are there any questions by members of the committee? Steve, I had a couple of questions. I'm sponsoring a bill that was requested by the County Commissioners Association to limit the authority, I think, if I'm stating it correctly, you can correct, to limit the authority of the Commissioner of Corrections on county jails, basically. I think Attorney Cohen had drafted that bill, but that and the jail funding issue, in terms of jail funding, is probably your biggest concern.
Right.
Is that fair to say at this point in time?
Well, yeah, that's certainly one of them. The jail funding, and yes, I'll leave it at that.
Okay, thank you. Representative Greenwood.
Excuse me, but isn't there one other, aren't you, there's something about allowing counties to bond for some maintenance?
That's not, no, that might be another
okay
representative that was asked of, but the one regarding, I think the gist of the legislation is to limit somewhat the authority of the commissioner on some jail evaluation standards. So basically to try to even the scales between the state and the county management. But Representative Greenwood?
Thank you, Mr. Chair. Commissioner Gordon, I just wanted to say thank you for coming in today and expressing what counties do. I served in your capacity as a commissioner for 8 years in Androscoggin, and you know, MCCA was an integral part of keeping the counties together, and we're glad that you know, there's still 15 hanging in there, you know, working together collaboratively.
Well, and you know, and in fairness, excuse me, but in fairness, Franklin County does not object to what we do and has asked. So I think really the 16 work together in many aspects. Thank you. I appreciate the comment.
And I appreciate your other comments about, you know, the fact that this commit or state government could make county government more, I don't know if the word powerful or more efficient
Regional.
or whatever. But, you know, that's a whole broader political discussion, having been a city councilor and dealing with the county. And so I welcome that discussion, but, you know, at some point the counties need to get together and suggest some legislation that they can be united on. I think that's been one of the issues in the past, is having them united on any kind of legislation in terms of county government. But I would look forward to that in the future as a discussion, because it certainly does present efficiencies in terms of the use of taxpayer dollars, potentially. So it's a good discussion that we should have in the future. I would just encourage the counties to maybe put forward some actual legislation that could be considered at some point. So does anybody else have any comments or questions?
Can I make one
Sure.
comment
Yeah.
back? I hear what you're saying, and a lot of times we're hesitant to put forth something like that because we don't want to antagonize a sister government, which is the communities. You know, I understand they want to make sure that they're overlooking and seeing what's being spent and done in their particular community, and to let somebody else, you know, be like letting the camel's nose get in the tent. So, but there are.
I appreciate that. I just mean that it's a political discussion that you guys need to take more of a role in at all levels. I'm just saying, I think that you guys would be the natural
proponents
entity to, proponents, thank you, for putting this forward, which would include a discussion with the municipalities, obviously, and trying to figure out what the role of the municipalities are, who's going to do what. I mean, we've had those discussions in Penobscot County about emergency dispatch and some other issues in terms of consolidating services. So I understand it's a tough issue and it takes time.
Well, there is one other thing that's raising its head up, and you think it works on a regional basis, and it's this expansion of the internet. You know, counties could play a partnership role there, because you can't have one community and then a space and then another community. That makes it kind of tough. but if you, counties could play a role there.
Oh, I'm all for efficiencies
Yeah.
and using the county as an efficient tool. So Representative Copeland?
Thank you, Mr. Chair, and thank you, Mr. Gordon, Commissioner Gordon, for speaking with us today. I have to agree that communication, I'm a recovering Saco City councilor. The communication needs to be open, and as a city councilor, I don't know that our county commission came to us at all. The only interaction that I had with them was approving, the budget. So I would say that maybe a little bit more proactivity to the municipalities, because I'm sure that economies of scale can be made, and I'm thinking also about transportation and some other ways. I know that you're primarily about the jails, but I think conversation is good and helpful.
Thank you. Any other questions or comments? No, I mean, I have a lot of stories to share about the Penobscot County Commissioners, but I won't bore people today. So any other questions or comments? Hearing none, seeing none. Mr. Gordon, thank you very much. Really appreciate the work that you're doing and your time. And your
thank you, and we may be back.
I'm sure you will, and we'll welcome you back.
Thank you.
Thank you.
Next is Nancy Smith from Grow Smart, Maine.
Hi, Nancy. Welcome, Ms. Smith. Welcome to state and local government. It's great to have you here.
Thank you. It's terrific to be here. I want to thank you all for the opportunity to check in with you. Some of you I know, some of you are new faces for me, but thank you, Senator Baldacci, Representative Matt Lack, and members of the committee. I'd like to take just a few minutes to introduce myself, Grow Smart Maine, and some of the coalitions that we work with. As for me, I am coming to you from my living room in Monmouth. I've been executive director of Grow Smart Maine since 2010. Prior to that, I've been a forester, a farmer, and a legislator. I served on the business committee from 2002 to 2010 and on ag conservation and forestry in my first and last terms. I served with Senator Rosen when she was Representative Rosen, and with Mark Bryan, and of course your own Randy Greenwood is currently representing me in the legislature. Hi, Randy. Grow Smart Maine is a statewide nonprofit, and since 2003, our mission is to build lasting prosperity without sacrificing the quality of life that defines Maine. We support communities in managing change. We do our work through advocacy, community engagement, and events. Equity and climate change are woven through all of our work because, frankly, if we don't do those things well, we're not going to achieve lasting prosperity throughout the state. Grow Smart Maine also earned the designation in 2019 as Maine's Rural Development Council through the USDA Rural Development. Grow Smart is probably best known for working with the Brookings Institute on the report Charting Maine's Future. This led and facilitated a statewide conversation about why we all choose to live here and resulted in 13 recommendations. In 2012, Grow Smart Maine released Charting Maine's Future Making Headway, which was a progress report to date with success stories for each of those recommendations and lessons learned. I will add that one of the lessons learned is the importance of action that truly is grounded at the local level to have lasting impact. I'll focus on our advocacy since that's probably of most interest to all of you, though I'd be happy to talk with you about our other work if you think it might be helpful out in your districts another time. We focus our efforts where our advocacy is most likely to have a meaningful impact on Maine's quality of place and efforts to build lasting prosperity. Relevance to this committee, I submitted written testimony for LD2, listened in on your work session this morning. That was fascinating, and I congratulate you all. That's a big issue and an important topic. There are other bills that at this point are interesting titles, and we're waiting to see what will come, but I expect I'll be before you on bills that address regional approaches to getting things done, planning capacity at the state, local, and regional levels. I want to talk with you about two of the coalitions that we're very much involved in. The first is the Maine Alliance of Smart Growth. This is a network brought together by Grow Smart Maine with a proven interest in smart growth, supporting economically and culturally vital downtowns and the natural areas surrounding them, working farms and forests, open space, and waterfronts. Our steering committee includes AARP of Maine, CEI, the Nature Conservancy, Island Institute, and the cities of Hallowell and Lewiston. One of our priorities this year with Merida, the Maine Real Estate and Development Association, is extending the sunset on the historic rehab tax credit. LD 201 has its public hearing in front of taxation next week. One of the things that I shared with you is the economic impact report of this tax credit. It includes the municipal fiscal impact because of the tremendous increase in property valuation, which of course supports municipalities either in more revenue or lowering the mill rate or a combination of the two. I hope that you'll support that bill as it moves through the legislature. The Maine Broadband Coalition is a group 1,600 strong across Maine. It represents hundreds of organizations, dozens of communities, and thousands of internet users. The coalition is a hub for information, policy support, and capacity building around high-speed internet in Maine. I serve on the advisory committee and on the policy committee. I noticed that there are several bills coming to your committee that are about facilitating virtual participation in government, either by elected appointed officials or by citizens. And I encourage you to support those bills because as we're all pivoting and adapting through the pandemic, allowing government at all levels to function in a transparent way and an efficient way benefits everyone. Beyond this committee, there are two bills I want to draw your attention to related to the Broadband Coalition. First, a $100 million bond proposal per the Economic Recovery Committee recommendations that's being sponsored by Senator Rick Bennett. Secondly, your own Representative Toole is sponsoring a bill to address issues with pole attachment that delay deployment of broadband. I think to close, just mention that you received an email from me in December congratulating you on your election, introducing you to the Broadband Coalition, and talking about speed testing. I hope that you'll use the link in the email I sent to go to the coalition, do your own speed testing, and share it with your constituents. This is a great crowdsourcing way to find out what the speeds are that people actually have to function with in their homes. It makes for more effective deployment of Connect Maine resources and the federal resources that are coming. You'll have a second email soon from Amy Winston of CEI, who also serves on the Broadband Coalition, with more information connecting your work with broadband. With that, I hope that you will consider me a resource, both in the legislative session and in your work with your community. I'm happy to answer any questions, and I wish you well in a unique legislative session ahead. Thank you.
Thank you, Ms. Smith. That was great. Are there any questions of Ms. Smith? We look forward to working with you on the broadband issue.
Great.
Definitely something that's definitely important to our economic future.
Absolutely. Wonderful. Thank you again for your time.
Thank you.
Bye-bye. Bye, Randy.
Next, we have Roberta Manter from Maine Roadways. After Roberta will be Bradley Sawyer, Ken Capron, Kimberly Cook, and Allison Susie.
Great. Welcome, Ms. Manter. And I just want to indicate I got to jump off and go to another hearing in about 5 minutes, Representative Matt Lack. So I'll sign off at the appointed time. Thanks. Ms. Manter?
Yes, thank you for giving me this time. Senator Baldacci and Representative Matt Lack, members of the committee. My name is Roberta Manter, and I'm the founder of an organization called Maine Roadways, which is an acronym for Residents and Owners on Abandoned and Discontinued Ways. How do I cram 50 years of history into the few minutes I've got here? We started being interested in this back in 1971 when my husband bought a little cottage out on the end of in the middle of a discontinued road. And one thing led to another. I joined him in 1981, And after 2 lawsuits failed to resolve the problems we were having with the road, we began to find that we were not alone. There are people all over the state that have roads like this. As a matter of fact, the map behind me shows just an idea of how many towns there are that have problem discontinued roads. We decided that the best way to try to solve some of these problems was to band together and try to get some legislation that would be helpful. It's been a long haul. I've served on 2 legislative stakeholder groups trying to sort this out, and we're making slow progress on it. We've chipped away at the edges of the problem, but it's been difficult because, as I like to say, there are 3 possible solutions and all 3 of them are unconstitutional. So how do you get around that? Well, back before 1965, when a road was discontinued, it automatically reverted to private property to the center line. And the problem with that was that it often left properties legally landlocked. And that meant that people would maybe buy a piece of property and then discover that they had no access to it. And there'd be bitter landowner disputes. Some things end up being like Hatfield and McCoy's feuds between landowners, or between landowners and the town, trying to get the town to maintain a road that the town said was no longer theirs. So in 1965, the legislature tried to solve the problem by changing the law so that when a road was discontinued, it automatically retained a public easement. Well, the problem with the public easement is that the public has an unfettered right of access over the road, but has no responsibility for it whatever. And as I like to say, it doesn't matter if it's a car or a house or a marriage or a road. If you keep taking out of it and don't put anything back, it's not going to last very long. So what happens with these roads is that the landowner tries to fix it for their own access. And as soon as the road begins to look passable, the general public says, oh, look, we can get in there now. And they start going in, tearing it up, and the landowner has to repair it again. And that's, in effect, they're making noise. Yep. Sorry. In effect, what happens is that the private landowner ends up maintaining a public road at private expense. And that again is unconstitutional. Well, my thought years ago was that, well, why not make it a private easement just for the property owners? Back years ago, some of the counties and some of the towns tried to do that. They tried to say that when they discontinued a road, they were going to keep what they called a private way. And their intention was to keep private access for the landowners. But the court came along and said, well, you can't do that because most of these old roads weren't purchased in fee simple. They were simply taken as easements over the land. And that means that if the road is ever discontinued, that land is supposed to go back to the abutting property owners. So you can't take that land and give the land belonging to the front property owner to the guy who owns the back property, because that's taking of private property for private use, and that's unconstitutional. So here you have three solutions, all of which are unconstitutional. My thinking on it was, well, if they're all unconstitutional, you get to pick the one that does the least damage. How can we do that? And the one that does the least damage is, well, probably the person that land was taken from back in the 1800s is not around anymore. He's not going to come back asking for his land back. And yes, the person who owns the land now could say, well, he was their predecessor entitled, they should now have title to that land. But how many people buy a piece of land thinking, well, someday this road is going to be discontinued and I can have my land back? People just don't do that. So what we finally came up with a solution for, at least partial solution in 2017, was to say that when a road is discontinued, you give the landowners a choice. If they want to, and this is strictly voluntary, they can grant each other private easements. And if they will do that, then the public easement can be extinguished. And the choice is, well, if it's a private easement, yes, you'll be giving up your land, but you'll be giving the use of it to just your neighbors. You will know who's going to be using the road. It can be posted as a private road. You'll have a limited number of people who will be responsible for the condition of the road and who have a stake in it because they own property that they need to get to. Or if you can't agree to do that, we have to keep a public easement so that we don't landlock those people in back. And if it's a public easement, it's a free-for-all. Anybody in the public can use it anytime they want, any time of the year, any time of day or night, and they have no responsibility for the road. So they can just come in, tear it up and leave. which is what we've got now. Or in most cases, that's what we have now. So this new legislation went through in 2017 to change how roads are discontinued. And it does seem to be working. It's sort of on a trial basis right now. A few towns are trying it. It does seem like it's a solution that's going to be workable. And just a few weeks ago, I found out that I wasn't the first person who had that idea. Back in 1976, there was a situation where there were 3 landowners on a piece of property that had an old road going through it. And nothing had officially been done with the road. It was still considered a county way, but nobody had maintained it in years. And so when the property owners tried to fix it up, other people would come through and tear it up. And they went to the county and they said, can you discontinue this piece of road for us? And the county said, well, we could, but if we discontinue the road, none of you has access. But if you will grant each other shared private access, yes, we will discontinue that piece of road. So that's what they did. In 1976, they all drew up deeds to each other, granting each other rights to the road, and the county discontinued the road. And that road has been working quite well since 1976. There's a minor question right now. A new landowner wanted to know whether or not he should give permission to someone else who wasn't in that agreement to use the road. But basically, it is working. So I have hope that that legislation is going to prove to be a good solution to at least part of the problem. We're still stuck with all the roads that have already been discontinued. And my hope is that they will be able to use the discontinuance law to discontinue the public easement in the same way that you would discontinue a town or county road. And that would allow them to go through that same process where the landowners can come to an agreement between them. Now that still leaves us with the problem of abandoned roads. Currently, when a road is abandoned in Maine, it requires the town to determine that they have not spent public funds on the road in 30 or more consecutive years. And if the selectmen determine that that's the fact, they can abandon the road and it immediately becomes a public easement. Well, here's that problem all over again. The problem is that this decision is made just by the selectmen. There is no requirement for hearing. There's no requirement for notice. There's up until recently, there was no requirement even for recording that had been done. We did get a change through in the law a couple of years ago that now they're supposed to register it with both the Registry of Deeds and with the DOT. So hopefully that will at least leave a paper trail that people can find. But again, we're stuck with this public easement. Well, maybe we can use that discontinuance law again to discontinue that public easement. But meanwhile, one of the problems with the abandonment law is that because there is no requirement for notice or hearing, it gets done and people don't know about it. Or when people find out, they'll say, well, wait a minute, we had evidence that the town has maintained the road. But once it's been decided by the selectmen, the only appeal for it is to go to Superior Court, which is frightfully expensive. And so a lot of these cases just kind of continue to be a problem because nobody has the money to fight it. So there is a bill coming up. I believe it's going to be coming up later before this committee, put forward by the Maine Woodlands, which will address the abandonment. We almost had it through last session, and then of course everything came to a screeching halt. So meanwhile, I get queries from people all over the state with problem roads. I try to help them find what their legal remedy might be just by showing them where the laws are. I always tell them I'm not an attorney, so I'm not allowed to give legal advice or interpret law. But I can also tell them that I've had more experience with abandoned and discontinued roads than most attorneys. So they can take it or leave it for what my advice is worth. I've had 3 new requests just in the last 24 hours. One of them was someone who had been in touch with me before, but they now have another logging company and tearing up the road, and they're wondering what they can do about it. The other 2 that I got this morning are brand new requests. Again, people having problems with other people using the road, or wanting to know who has what rights on the road. One was a real estate situation, trying to determine what the access to a property will be. So if you have any questions, I'd be happy to try to answer them.
Thank you, Ms. Manter. I'm absolutely fascinated. we do have modest little problems here in Knox County, but I'm sure that other people in more rural parts of the state have greater issues with this. Mr. Greenwood.
Thank you, Madam Chair. Ms. Manter, I had the privilege of working in the 127th legislature, and you and your husband were a wealth of knowledge during that year. So I want to thank you for all the work you do.
Thank you.
Are there other questions for Ms. Manter and about main roadways? As you say, we will be seeing you later on in this legislative session. Representative Copeland.
Thank you, Madam Chair. Thank you for speaking with us today about this important issue. I know that in some municipalities, there are laws and procedures on paper roads and abandoned roads and so forth. I'm wondering if this is better left to local municipalities. Can you tell me what you think about that? And
Well, I can tell you that we've seen some rather creative solutions, quote solutions, taken by various towns. A lot of towns don't really know what the law is, so they sort of make it up as they go along instead of researching it. And it's had some horrible consequences. We've had towns that have decided in advance that they were going to abandon a road, which is not the way it's supposed to work. An abandoned road is supposed to be a road that everyone has forgotten. And somebody comes along and says, oh, look, there used to be a road there 30 or 40 years ago. Let's demand that the town repair it. And what towns are doing now is saying, well, we're just going to abandon this road, and 30 years from now, we can get it on the record as being abandoned. They're not supposed to be able to do that. There is a law that they have to keep their roads safe and convenient for the public with motor vehicles. And so when they fail to do that, that's a problem. We've had other towns that have told one person one thing and told another person something else, and it ends up being a huge feud because one person thinks that it's a public road and another person thinks it's a private property. So we've had people shooting at each other. We've had people threatening each other with a machete or a medieval style battle axe or a piece of pipe, or the list goes on and on. So I think
how
there
about
needs
going
to
to the
be
registry of
something
deeds in the
specific.
county? And oh, I'm sorry.
No, go ahead. What were you saying?
I was just wondering if they would go down to the registry of deeds and do, a title search basically to find out. I mean, and you touched on the fact that a lot of people are able to communicate appropriately and come to an agreement. And wouldn't that be nice if that could happen?
Yeah, there are situations where there's just an amicable agreement between neighbors, and that works fine until one of them sells their property, and maybe the new person who comes in isn't as agreeable.
Right.
Sometimes one of the cases that I had call in this morning, they're trying to reach an agreement with someone who owns a piece of property but lives out of state, and they haven't been able to reach him. So again, there needs to be a consistent way of treating them. I don't think you can leave it to each town to come up with it on their own. Although there are situations where something that it maybe doesn't exactly conform to the law, but doesn't conflict with the law either. Sometimes those situations can work out rather well as long as everyone agrees to it. I forget which one of you says that you thought there might be problems in rural areas. Well, if you can see the map behind me, we actually have a lot of problems in congested areas. Last night I went down through all the people that are now on this committee and found that for every one of you, you've got at least one town in your district that has a problem road in it. And some of you have a whole string of towns with problem roads in them in your district. So it's pretty widespread across the state. We've even got ones up in the north end of the state. There aren't as many up there, but we do have, I'm going to say a dozen or more pins right up in the very northern part of the state, and probably another dozen through the middle part of the state, just above what shows on the map behind me.
Thank you.
Thank you. I didn't mean to say that folks in rural areas had more problems, but yes, in my town in St. George, we do have issues with abandoned roads and who owns roads and who's responsible for roads. And I know that's an issue. And it sounds like it's quite a complicated and convoluted issue that nobody has seen, except for you, has stepped forward to offer ways to make it work for everybody involved.
Yes, as a matter of fact, if you want to look up my website online, if you can't remember the name Main Roadways, all you have to do is type in Discontinued Roads Maine, and Main Roadways will pop up as a website and a Facebook page right at the top of the list, which shows there really isn't a lot else out there to help people. So if you know of anybody that's having a problem with one of these roads, just tell them Google Discontinued Roads Maine, and they'll find me, and I'll see what I can do to help them research the deeds or research the history of the road. I have a lot of resources. I've been doing this for a long time, and I can usually find the information a lot faster than a person trying to wade their way through it on their own.
Thank you. Do we have any other questions for Ms. Manter while she's here? Thank you, and I look forward to our discussions later on this session. Thank you very much for coming.
Thank you for your time.
Next is Bradley Sawyer. Welcome, Mr. Sawyer.
Thank you.
If you could tell us about yourself and your organization, we'd love to hear from you.
Absolutely. Thank you. But I believe Senator Baldacci has left, so Representative Matlick and members of the State and Local Government Committee, thank you for having us today. My name is Brad Sawyer. I'm the Director of Government Affairs for the Maine Rural Water Association. Wonderful to see some old friendly faces from my previous bicentennial days. I made sure to put on the Maine 200 button for you all. Outside of that, the Maine Rural Water Association is a nonprofit trade association representing just under 300 water and wastewater systems across the state. Our membership spans from the smallest water districts that have 10 to 20 connections to some of the largest utilities in the state with thousands of water and sewer connections. That said, we're here to assist all facilities in this field, and last year visited 529 systems, spending almost 2,800 hours on site. We have a statewide policy committee that provides guidance and information to rural water staff on legislative and regulatory issues that are of concern. It's fair to note that I will not be in front of you much the next 2 years, but there are some issues that come up, and I wanted to put a face to the name for you folks. It's notable that the vast majority of these utilities are municipal or quasi-municipal entities that are responsible to their ratepayers and not the pursuit of profit. We call them ratepayers, you call them taxpayers, but I assure you they are the same people and their wallets are the same. We currently have a full-time staff of 17 and provide technical assistance to training for and advocacy on behalf of the water and wastewater industries. Our training slate is quite robust. In 2020, despite the pandemic, we were able to hold 90 trainings, both in person and virtual, accounting for over 2,400 classes taken by operators, staff members, and board members of these utilities. And we do hold trainings that are specifically tailored to all of those groups, including some that are tailored just for extremely small utilities. We're also a leading partner in technical assistance for these utilities. Through our Circuit Rider program, we're able to assist utilities in real time as they deal with issues of leak detection, pipe and valve repair, wastewater testing lab, regulatory compliance, financial services, or any aspect of running a utility. These may sound mundane on the surface, but they can threaten the safety and quality of drinking water and pose hazards to the environment that we all want to protect. Our members take their charge to protect the health and safety and viability of Maine's environment very seriously. as a quick aside from my prepared comments, I'm a resident of Augusta, not in Representative Dorr's district, but fairly close. And a couple of years ago, the local utility had to tear up one of the rotaries, and people were upset that the rotary was torn up and asking why it had happened. Well, a valve broke, and the date on that valve was 1886. I personally think if we have to do that every 140 years, I think we're okay. But I'll leave that to the people to decide. We also have people that help with source water protection. It's fairly self-explanatory. It's easier to protect water and keep it clean in the environment so we can provide clean drinking water than it is to treat dirty water. We do a number of things. I don't want to take up much of your time as I won't be a major part of this committee, but I'm happy to speak with anyone regarding water and wastewater utilities, issues to our industry, and where folks can be of help if this is an area that you would like to learn more about and participate in at a higher level. So thank you very much, and I appreciate the time.
Thank you, Mr. Sawyer. Representative Copeland.
Thank you, Madam Chair, and thank you for being here, Mr. Sawyer. I would like to talk to you, so if you can make a note to contact me. I'm particularly concerned about wastewater. I sit here on the Saco River, and there are two sewer facilities on there, and both municipalities, Saco and Biddeford, have done a lot towards the sewer separation, but there are times when the water is not good. In fact, the water out here in Saco Bay is not clean enough to have shellfishing. And that's troublesome on so many levels, but boil it all down to an economy level. You know, if it was open, we could have more jobs. We could get aquaculture. There's a lot of things. And there's also the Goose Fair Brook that is kind of goes behind a lot of cottages in Old Orchard Beach. And it's questionable whether they're, polluting the water. There's evidence that the water is polluted at the end of it when it comes out into Saco Bay. So I'd like to, if I do nothing else in this term, I would like to get that water clean and get some fishermen out there and get some aquaculture built industry here in Saco. Some more. We have some, but more. If you could talk to me about that, I'd really appreciate it.
Absolutely. I'd be happy to reach out and see if we can't find some answers to some questions.
Thank you.
Representative Toole.
Thank you, Madam Chair, and thank you, Brad, for coming to join us today. I want to say how much I appreciate the Maine Rural Water and some of the work you folks, Janet Abramson, did in my sewer system situation sorted out. And that was a good send, and it got us on the path to getting some things done. I wondered if you could talk a little bit about PFAS, which is something that is becoming a huge issue for towns around the state. And I know there's legislation around that that's in other committees, and wondered if you could just talk about that and what you folks are doing.
Absolutely. And I'll try to give the 10,000 foot view, and I'm happy to dive deeper if folks would like. So from our industry, we have two sides of this. We have PFAS in drinking water and PFAS in the wastewater world. Drinking water, to take PFAS out can be incredibly expensive. Primarily, so far, this has been a private well issue. And I believe the number that the department cited when talking about well remediation was $24,000 per well for residential wells. On a municipal level, it would be much more costly than that. Numbers are in the low millions. So for some of the larger systems, it is certainly a large bill, but can be spread out among thousands of customers. If a small system, say a system with 100 customers, found elevated levels of PFAS in their source, their options would be to treat it or to find a new source. Both of those options are extremely expensive, and no one has a great answer as to how that would happen. The fact of the matter is, people can't afford water and sewer bills on the order of thousands of times more expensive than they are now. And one of the first things I was told when I started speaking to committees was, don't use metaphors, don't use hyperbole. And while that sounds extreme, it isn't out of the realm of possibility. On the wastewater side, the issue is when material comes into that facility, it is treated, the liquid is discharged, and the solids, what's left over, has to be dealt with somewhere. And what you do with that is a very difficult conversation. To treat PFAS that is left in that solid, we don't have, the industry doesn't have a good example or a good answer for right now. And so do we landfill it? Do we incinerate it? Do we apply it to agricultural lands? That's all part of the discussion. Our major note, our industry's major note, is that we didn't create any of this material. We don't use this material, and we are not making money off this material. We are the receptacle that all of us, all people, are putting PFAS into. If I was a betting man, I would bet that every single one of us on this call has a certain amount of PFAS in our blood. I was personally wearing a fleece earlier today that I imagine has some level of PFAS in it. I make that decision knowingly. It's a lovely LL Bean fleece, but it's an example of just how pervasive this is in our society. As mentioned before, our customers and your constituents are the same people. We firmly believe that the creators and the manufacturers of these chemicals that largely knew what was in them, and I think one could make a point that they may have even known some side effects of them, should bear the cost of that remediation and cleanup, and not the people of Maine, who we both represent, but in different capacities.
Thank you.
Thank you. Representative Bryant.
Thank you, Mr. Chair. I just wanted to say hello to Bradley there. I know that he was instrumental in getting us started with the Maine Bicentennial Commission. He did a great job, and I'm sure he'll do a good job here today. But thank you, welcome, and thank you.
Thank you, Representative. Always a pleasure to work with you.
Thank you. Do we have any further questions for Mr. Sawyer? Thank you, Mr. Sawyer, for coming. It's been very informational. I appreciate it.
Thank you.
Next is Kimberly Cook.
Hi there, can you hear me?
Good afternoon, Ms. Cook. Welcome to State and Local Government.
Thank you for having me. I appreciate it. I appreciate the opportunity, Representative Matlack, Senator Baldacci, if he's back, and members of the committee. I'm Kim Cook, and I live in Portland, and I am a lawyer whose practice focuses on government relations and public affairs. And I've had the privilege of representing a variety of clients at the State House, or now virtually at the State House, before the legislature and executive branch for about the past 15 years. And in addition to my firm, which is Government Strategies, I am also this year working with my colleagues at Eaton Peabody and working with a couple of their longtime clients. And that is why I'm introducing myself and the Mayor's Coalition to you today. So the Mayor's Coalition is a nonpartisan group formed in 2012, And it currently includes the mayors of 9 Maine communities, including Augusta, Biddeford, Lewiston, Portland, Rockland, Saco, Sanford, South Portland, and Westbrook. And together they have a combined population of nearly 250,000 people. The purpose of the coalition, it advocates for state and federal policies that recognize the important role that Maine cities play in providing vital services to Maine people across the state, and the positive impact that Maine cities have on the economic strength of our state. The coalition seeks to work in partnership with Maine's state and federal elected officials to meet the needs of all Maine people. And so I wanted to introduce myself, the coalition, the Mayor's Coalition, and please invite you all to reach out to me if you have any questions regarding the coalition, or if we can be a resource for any of you as you deliberate on all the issues that are before your committee.
Thank you very much.
Thank you for the opportunity.
Does anyone have any questions for Ms. Cook and the Mayor's Coalition? Thank you very much. I look forward to hearing from you throughout this legislative session.
Great, thank you so much.
Finally, we have Allison Susi.
Good afternoon, Ms. Susi. Welcome to State and Local Government.
Good afternoon. Thank you so much for having me, Representative Matlack and members of the State and Local Government Committee. I am Allison Susi. I am the Chief Operating Officer and the Director of Government Affairs for the Maine Tourism Association. We are also represented by Mitchell Tardy Jackson, so you may excuse me, hear from them on our behalf at some point in the future. Maine Tourism is a nonprofit association, and we represent all tourism interests in Maine: lodging, retail, restaurants, camps, campgrounds, guides and tours, cultural and historic attractions, outdoor recreation, and amusements. We're the largest tourism-related association and the only one that does represent all aspects of tourism. We've been in existence since 1922, so we will have our 100th birthday next year. MTA operates the 7 state visitor information centers that you may pass by in Kittery, Yarmouth, Freiburg, Camden North and South, Calais, and Holton. We also produce the official state travel planner called Maine Invites You. We've been doing that for the state since the late 1920s. We also produce the official state highway map, and we handle the state's toll-free visitor phone line. Because of these services, we're a unique association in that we not only work for our members, but we also have this visitor-facing component of helping those folks through the call centers and through the information centers themselves in person. We are sometimes confused with the Maine Office of Tourism, which is the state bureau that falls under DECD. And we certainly work very closely with them because of these state services that they contract with us for, but we are a private nonprofit association. As you know, the tourism industry has been hit extremely hard by the pandemic. So one of our main priorities this session will be to keep the state's tourism marketing fund whole. That fund it gets its money from the meals and lodging tax. 95% of all the money that comes into the state from the meals and lodging taxes goes to the general fund and is spent in the budget, however all of you see fit. 5% of that money goes back towards tourism marketing promotion, which the Maine Office of Tourism is in charge of that fund. So since those revenues will be dramatically decreased as they have been over the past year and will continue to be below normal, the small amount of money that goes towards tourism marketing promotion will be less than normal. So one of our goals is to try and keep that fund whole because investments in tourism, according to the state's research, has an ROI of 24-to-1. And that's why a strong tourism economy benefits everyone in the state, not just tourism businesses themselves. And so when tourism rebounds and is strong, the rest of the Maine economy can be strong too. Some of the issues you may see us before you when you deal with issues of short-term rentals and municipalities handling of those, and certainly if there are certain types of state contract issues, because as I say, we do work so closely with MOT. So that's the quick overview. I'm happy to answer any questions you may have, and I appreciate your time today.
Thank you very much. Does anybody have any questions? Representative Copeland.
Thank you, Madam Chair, and thank you for coming and speaking with us today. You just touched on something that perked my interest. So, short-term rentals, that seems to be a hot spot. You know, there's the battle between affordable housing and tourism. So, what are your views on that?
Right. So our view has been, and we've testified on bills in the past session, that when there are bills in to limit a municipality's ability to deal with short-term rentals, we oppose those. For us, it's a matter of, we know that there are places where there are great problems with that dynamic tension between the two. And if a municipality wants to regulate it in some way, our position is that's none of our business. That's up to municipality. So that's where we get involved in that. Obviously, short-term rentals are great as one piece of tourism, but for us, it's up to the municipality to deal with those.
Thank you.
Thank you. Do we have any other questions for Ms. Susi? Thank you very much for coming to chat with us. I appreciate this.
Great. Thank you so much.
Are we?
That is it.
That is it for this afternoon. That's wonderful. Actually, very informative. It's amazing the breadth and the scope of what state and local government deals with. And this is a good opportunity to hear more about what we will be doing this session. So thank you for setting this up. There being no other business today, I need a motion to adjourn. Is that
So
true?
moved.
Thank
Second.
you.
Okay.